Okay, members, just a brief overview of today's meeting. There was the oral evidence session with the Minister of Justice and the departmental officials on the proposed consultation of the Stocktake of policing oversight and accountability arrangements and the Police Ombudsman's 5-year review. An oral evidence session with the departmental officials on the key issues raised in the written and oral evidence on Part 2 of the Justice Sexual Offences Trafficking Bill, which covers the trafficking and exploitation elements. Consideration and approval of the draft committee report on the Protection from Stalking Bill, and consideration of information for the Department of Justice on the PSNI and the Abortion Service Safe Zones Bill, and consideration of 2 proposed statutory rules to make changes to the court rules, and written papers on the results of the consultation on modern slavery and human trafficking, transparency in supply chains, and further information on the implementation of Section 28, the Domestic Abuse Waiver for Legal Aid. Just to advise members is that they are welcome to use the mobile devices as long as they are in airplane mode and the devices are muted. This includes members' tablet devices. They can connect to this end of Wi-Fi. They are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to the matter under consideration. Any member who has interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. I just seek the agreement of members for the oral evidence session on the Justice, Sexual Offences and Trafficking Bill to be reported by Hansard, and for a retrospective Hansard of the oral evidence session with the Minister to be produced depending on the capacity of Hansard to do so. Agreed? Item 1 are the apologies. We have an apology from the Deputy Chair, Sinead Ennis, Emma Rogan and Peter Weir. Just to advise members that Gemma and Rachel and Doug, only Gemma and Rachel are joining us by and Sinead are joining us by Starleaf, and Doug and Robin are with us here in the room 30. And just in regards to the delegation of authority to vote on behalf of another provided under by Standing Order 115.6, the Deputy Chair, Sinead and Emma have delegated their votes to Gemma, and Peter Weir has delegated his vote to myself. That brings us to agenda item 2, the draft minutes of the meeting held on the 30th of November and on the 2nd of December 2021. You'll find those at pages 5 to 22 of the meeting pack for the draft minutes of the meeting of the 30th of November, and pages 23 to 32 of the meeting pack for the draft minutes of the meeting held on the 2nd of December. And are members content that these minutes are true reflections of the proceedings of the meeting held on the 30th of November? Agreed. And are members content that the minutes are a true reflection of the proceedings of the meeting held on the 2nd of December? Agreed. Thank you. Item 3, matters arising. Item 1.6, the Protection from Stalking Bill, notes of informal meetings with individuals. As agreed by the committee, a number of informal meetings were held with individuals who have experienced stalking behaviour or who have specific experience in this area. These meetings took place via the Teams, with a small number of members and committee staff attended to take note of the key points highlighted during those discussions. Notes of the informal meetings have now been agreed with some of the individuals concerned, and the relevant papers can be found at pages 34 to 54 of the meeting pack. 2 further notes are at pages 4 to 24 of the table pack, one of which includes written testimony from an individual who was unable to attend a meeting as previously planned. The notes will be anonymised and included in the appendices of the committee report. Notes for 2 meetings are still to be finalised with the individuals concerned and will be provided to the committee before publication in the appendices to the report. I just thank those members who did help in terms of those various discussions. Their attendance was very much appreciated, and thanks to the staff as well who assisted on those separate occasions. Items 7 and 8, the Justice, Sexual Offences and Trafficking Bill, further information following the oral evidence sessions. Bernardo's and Professor Claire McGlynn have both provided additional information following their oral evidence to the session on the Justice Sexual Offences and Trafficking Bill on the 11th and 18th of November, respectively. Relevant information can be found at pages 55 to 63 of today's meeting pack. And just for members to note the additional information which will be added to the electronic bill folder on the bill web page. Item 9, the Protection from Stalking Bill, correspondence from the Department of Justice. The Department of Justice has written to the Committee regarding the Committee's agreed amendments to the Protection from Stalking Bill. The relevant correspondence can be found at pages 25 to 26 of the table pack. The Minister is now prepared to supplement the Department's amendments with the Committee's additions and has instructed officials to engage the OLC to draft revised amendments with a view to sharing the text of the revised amendments in advance of consideration stage. And just to, I suppose, at this stage, probably to welcome the approach that has been taken by the Minister. However, I suppose it would be advantageous for us to write to the Department welcoming the approach and advising that the Committee wishes to see the revised amendments in advance of the closing date for submitting amendments for consideration stage, to provide an opportunity for us to consider them. And I think that that would just be a prudent step to take, just to ensure that we have, it's not that we are in any way questioning what may or may not be the intent, but certainly it would give us, I think, the confidence that that we're proceeding along the right lines in regards to this. So if you're agreed, we would take that approach. Thank you. Agenda item 4, the Stocktake of Policing Oversight and Accountability Arrangements and the Police Ombudsman's 5 years proposed consultation. The Justice and the departmental officials will attend the meeting via Starleaf today to discuss a proposed consultation on the Stocktake of Policing Oversight and Accountability Arrangements and the Police Ombudsman's 5-year review. The relevant papers... Sorry?
Defer that one.
Oh, yes, sorry. Apologies. Well, we would go to that, but we don't have any indication yet that the Minister is with us. So, have we any indication, Christian, of the time?
Sorry, there was an executive meeting called for 1 o'clock, so, and then I think it was deferred until after 1:15 or slightly later. So the department had asked if the committee would be willing to swap around the oral evidence sessions just to give the Minister time to finish the executive meeting and then join the committee.
Apologies, I'm just seeing Sinead's hand up there. Sinead?
Sorry, yes, Chair, it was before I realised that there might be a delay in this matter, but I just wondered if, Chair, if you or the clerk could confirm. I was a little bit confused by this. Is this a statutory requirement for a minister to bring something to a committee ahead of a consultation? I just didn't fully understand the nature of what it is that's in front of us.
Kristen?
Yeah, I think normally the Department of Justice would advise the committee before they go out to consult on anything. In this particular instance, the Minister had sought views of a range of stakeholders and officials had come to discuss the Stocktake with the committee a good few months ago, after which I think they went ahead, they went and spoke to other stakeholders and developed what's, I suppose, the proposals that are now in the consultation document. So I think they wanted to come and just update the committee and brief them before they go out to consult.
Okay. Have enough, Sinead?
Okay. Yeah, Chair, I just wasn't sure. I thought it was that she was seeking, the Minister was seeking the approval. I just wasn't sure what the ask of the committee was, but if it's just a briefing, that's fine. Thank you.
Thank you.
I'm not, I'll be honest with you, Sinead, I think they want to outline what's in it. I don't think they're asked, well, I'm not sure, but we can clarify when they're here. But normally the committee will note a consultation and consider the issue once the consultation has taken place, unless there's particular issues before that.
Because this is not going to be something that's going to be in this mandate anyway. There'll be no legislation brought forward as a result of this. This is into a new mandate, so I suppose it really only is for information, but we can clarify that point that you make, Sinead.
Yeah, I think, Chair, I did read somewhere in it that they were seeking the approval or some, of the committee, and I thought it's just highly unusual. So yeah, I'll take your lead on that when it comes. Thank you.
Thanks, Sinead. We go to item 5 then. Will the officials be available, Kristen?
Should be, yeah, they should.
Item 5 is the Justice Sexual Offences and Trafficking Victims Bill, Part 2, the Trafficking and Exploitation. Department officials will attend the meeting today via Starleaf to discuss the key issues raised in the written and oral evidence received by the committee on Part 2 of the Justice Sexual Offences and Trafficking Victims Bill, which covers trafficking and exploitation. The relevant papers are at pages 252 to 368 of the meeting pack, and a paper outlining the key issues raised in relation to this section of the bill is at pages 31 to 33 of the table pack. This is an opportunity to get any further information and clarification they need on Part 2 of the bill and the issues and the proposals covered in the evidence received by committee. Just to advise members that KRNI has provided additional information following its oral evidence session on the bill on the 11th of November, and this can be found at pages 252 to 254 of the meeting pack, with a joint response from Migration Justice Project organisations in follow-up to their evidence session on the 11th of November. And that's also in the table pack at pages 34 to 43. And for members, just to note that the additional information which will be added to the electronic bill folder and the bill web page. And can I welcome to the committee this afternoon again Brian, the Deputy Director of the Criminal Justice Policy and Legislation Division, along with his colleagues Ronnie Pedlow, Head of Modern Slavery and Human Trafficking Branch, and Alison Redmond, Head of the Organised Crime Branch at the Department of Justice, and just ask them to make a few comments, and just in relation to the procedures of the committee, to remind them that the Hansard will take a transcript of these proceedings and will be published on the committee's web page. But you're very welcome to the committee this afternoon, and can I just ask officials to make remarks on clauses 16 and 17 of the bill, and any comments that they wish to make in relation to the issues and the proposals made in the written or oral evidence received by the committee in relation to Part 2 of the bill. Thank you very much.
Right. Thank you, Chair. I'm here very much as the Senior Bill Manager for the legislation, and sitting with me are Cathy Galway, who is actually the Head of Protection and Organised Crime Division in the Department, who owns this policy area, with her colleagues Ronnie Pedlow and Alison Redmond. We are here at the committee's request to discuss elements of the Sexual Offending and Trafficking Victims Bill that relate to trafficking victims. I will offer a brief introduction, but will lead all the hard questions to Cathy, Ronnie and Alison, who are responsible for the policy area. At the outset, I should register our gratitude for the opportunity to brief the committee. We have given careful thought to the issues raised with the committee by key stakeholders in relation to the trafficking clauses, and will offer our perspective on some of the themes running through that evidence. Members may find it helpful if I briefly set out the background to the trafficking victims provisions in the bill, and offer our views on the points raised on improving services for victims of trafficking and exploitation. My colleagues and I will then be happy to answer any questions that you may have. Part 2 of the bill deals with trafficking and exploitation. In Article 16, this extends statutory assistance and support to adult potential victims of slavery, servitude, and forced or compulsory labour, where this is not an element of trafficking. As you know, the provisions of assistance and support to potential victims, where there is no element of trafficking, has been in place in Northern Ireland since March 2016 by virtue of a policy decision taken by the then Justice Minister. However, this has not been a statutory requirement. Placing the existing arrangements onto a statutory footing has been welcomed by all stakeholders. It is universally seen as a positive step towards ensuring that all victims of modern slavery are provided with assistance and support while they are in the national referral mechanism. As members will appreciate, the national referral mechanism is the framework for identifying and referring potential victims of modern slavery and human trafficking. It ensures that they receive the appropriate protection and support. Reviewing the evidence presented to the committee, it is noteworthy that whilst welcoming the proposed changes, some organisations like to see our legislation go further than what we consulted upon. They propose going beyond our provision to include other victims and change the nature of that support provision to prescribe a statutory period of 12 months for those who have a positive conclusive decision. The rationale is that most confirmed victims of modern slavery are unable to access support with any degree of security from the point at which their status is confirmed. The suggested extension is presented as a means to facilitate reintegration and recovery, as well as enhancing protection from re-trafficking. The existing Northern Ireland legislation makes statutory provision covering assistance and support for victims and potential victims of human trafficking. As you know, Section 18 of the Human Trafficking and Exploitation, Criminal Justice and Support for Victims Act 2015 places a statutory duty on the Department to provide assistance and support to adults who are potential victims of human trafficking during a 45-day recovery and reflection period pending determination of their status as victims by a competent authority. This is in line with Article 10 of the Council of Europe Convention on Action Against Trafficking in Human Beings. As noted by some stakeholders, Section 18(9) of the Act already provides for support to be continued on a discretionary basis following a positive conclusive grounds decision. This is based on assessed need, and I would stress that there is no minimum or maximum period prescribed. The existing subsection 9, albeit discretionary, enables the Department to continue providing assistance to a victim under this section for such further periods as the Department considers necessary, and I'll return to that point later. So, we are currently able to continue to provide support to an individual beyond the point where a positive conclusive determination is made, where there is an assessed need to do so. Subsection 5 and 6 of the 2015 Act detail how the support under Section 18 is to be provided. This includes that it may be provided in a manner that takes due account of the needs of the person as regards safety and protection from harm, and it must be provided to meet the assessed needs of that person. Organisations have highlighted that without support, clients face significant barriers to moving on in such areas as social isolation, homelessness, poverty, mental health issues, alcohol, substance misuse, a range of possible outcomes. The Minister very much recognises these concerns and has undertaken to consider extending support requirements. While work to scope extended support arrangements has unfortunately been delayed by other pressures, and in particular COVID, it is a key issue that we are beginning to explore and will focus our attention on in the early part of next year. The Department has now established a separate, dedicated modern slavery team in addition to the organised crime branch, in recognition of the workload and complexity across both areas of work. Both teams will continue to work closely on these issues under the auspices of the organised crime task force structures. Our intention is to take forward this scoping work as a matter of urgency and to engage with stakeholders in the new year to establish the longer-term support needs of victims. This is a key element in the development of a longer-term strategy for human trafficking and modern slavery. The Minister's aim is to focus on developing and implementing targeted action plans rather than devising and consulting on strategic frameworks each year. It is fair to say that we've not made as much progress in this area as we would have liked, but it is important to scope out the range and type of support that needs to be addressed and how possible solutions will work in practice. Simply applying a one-size-fits-all, time-bound response without this scoping work and detailed consideration is not the best way of meeting the complex and differing needs of confirmed victims. There is a very clear need to develop a focused and well-targeted approach. Moving straight to legislation would risk us producing poor law. Its implementation would distort existing provision, and its impact would be hard to predict at this point. While some organisations have indicated that this will not result in significant pressure on resources, it is important to take the necessary time to consider this in more detail and in the context of support that is currently provided in excess of 45 days in 95% of all current cases. Members will be interested to note that for cases going through the national referral mechanism, support provided is typically 150 days, and in some cases this has been in excess of 500 days. So the picture is somewhat more complex, which then may have been presented perhaps in some of the earlier evidence to the committee. Moving straight to legislation in this area is not the answer. The Minister has made clear commitment to press the work to increase support for trafficked victims, but we need to take the time necessary to develop an appropriate and well thought out framework supporting enhanced statutory support. Through the Assets Recovery Scheme, we are already funding a project to prevent the re-exploitation of modern slavery survivors and empowering them to move on to lead lives that are not defined by their past circumstances. This project, which is underway, runs until the end of March 2022 and will be invaluable in informing the Department of a potential model for extending support. Many of the issues raised with the committee were also raised by respondents to the consultation on this year's modern slavery strategy. The longer-term strategy will enable us to address a wide range of issues. We will be consulting after Christmas on the duty to notify, and then the introduction of slavery and trafficking risk orders, two of the areas which were flagged in the evidence presented to the committee. There will therefore be another opportunity to propose legislative changes to the 2015 Act. Our intention is to bring forward proposals for extending support needs after engagement on the scoping work planned for the new year. And that engagement would certainly be involving all of the relevant NGOs and other interests. Some organisations have asked the committee to consider a wide range of issues, some of which go well beyond the competence of the Minister of Justice. Issues listed included jury direction, compensation, extension to universal credit, immigration policy, social security entitlement, statutory defence for survivors of trafficking, quashing historical convictions, healthcare entitlements for survivors of trafficking. These are all important issues, but again, we need engagement with both with statutory, non-statutory, also with other departments, such as the Department for Communities, Health and the Executive Office, before we'll be able to take them forward. Many of these issues are cross-cutting and would potentially require executive approval to be progressed. There may also be some important procedural issues in using a justice bill to amend relevant legislation for other work areas such as health and welfare. It is clear there's a wide range of issues that we need to address, not least the issues raised in response to the consultation on the recent modern slavery strategy. And in response to the Sigini recommendations as well, another around support and new statutory measures, including the statutory defence. The longer-term strategy will enable these and other issues to be taken forward in collaboration with partners and in a coherent and structured manner. Our aim is to ensure that we are doing everything possible to identify and support victims and pursue offenders, but we still need to develop our thinking on the best routes to delivering such support. Turning to the three-year strategy, which is in Article 17 of the bill, this article amends the existing requirement to publish a modern slavery and human trafficking strategy, moving it from once every year to at least once every 3 years. Taking this change, which may look administrative, will allow the department and its partners to focus on the implementation of the range of actions needed to underpin the strategic goals and to monitor progress. Many of the issues raised by the committee and during the consultation on the existing one-year strategy will take time to resolve, and the implementation will undoubtedly span more than 1 year. But certainly on this area, we note all respondents support this clause. We also note and agree that the department should publish annual progress reports. This is in line with a recommendation from Sigini's modern slavery and human trafficking report, and the Minister has separately given the commitment to that effect. It is important to acknowledge that there has been a considerable and concerted multi-agency effort to tackle modern slavery and human trafficking in Northern Ireland, both in policy and practice terms over many years. The numbers coming through the national referral mechanism process are increasing. I think they may have trebled over the last year or so. And whilst this is a measure of our collective success in identifying potential victims and bearing down on this criminal and criminal exploitation, there is simply no room for complacency. There remains important work still to do to ensure that all our efforts to tackle these crimes and violations are fully coordinated and connected. Moving to finish off my presentation, the two clauses in the bill provide an opportunity to further protect and support victims. They provide an appropriate, realistic time frame to strategically tackle this issue and to help support victims of modern slavery and human trafficking in Northern Ireland. The two clauses are part of a process which will continue into the next mandate, a process to deliver important strategic changes and respond to the Sijini recommendations. The Minister's ultimate aim is to significantly improve support for victims of trafficking in Northern Ireland while identifying and eradicating this pernicious activity in our community. I hope this update has been helpful, and myself and my colleagues are very happy to answer any questions that the members may have.
Thank you, Brian, very much for that. And maybe if we just return to the clause 16, back in a written assembly question, I think it was a few months ago anyway, the Minister had said that work to scope extended support arrangements will commence in April 2021, and it's not possible at this point to provide a definitive timescale for completing the scoping exercise. Can you just confirm, has the scoping exercise commenced in April, or are we commencing a scoping exercise in the new year, or are we continuing the scoping exercise that did commence in April of 2021, said by the Minister in the House, just so we have clarity around that point? And if we have commenced it, what has the indications been of the magnitude, nature and outcomes of that particular scoping exercise?
Well, I'll maybe pass over to Cathy Galway, who will pick that point up. Cathy?
Thanks, Chair. Yes, it was our intention to start that scoping exercise in April 21, but a number of other competing priorities at the time. We were very focused on criminal finances and different aspects of legislation to try and get through before June. That has slipped slightly, which Brian referred to in his opening remarks, and it's regrettable that we haven't made more progress on that. But we now have a dedicated team established for modern slavery and human trafficking, separating it out from the organised crime team in recognition of the workload and the complexity around some of these issues. And that work has started, and we would want to focus on that much more in the new year. Ronnie might be able to give us a bit more background on what's happened so far.
Okay.
Yes, thanks, Cathy. Chair, the new team was set up basically in July of this year and working forward, and obviously needed to get to grips with the basics of the issues. But the team is working under the three headings of pursue, protect and prevent, and under the protect and prevent headings, one of the team is been doing a lot of work with NGOs in reaching out to them and reaching out to other non-statutory body or statutory bodies, and in terms of really starting to take that work forward. So although we would intend that it will begin to really take effect in the new year, the work has already started and we are getting to grips with it.
And Ronnie, in terms, and it's good to have you at the committee today, and we'll try and engage with you more today maybe than the last day you were with us. I think you got it relatively easy that day, so we'll maybe try and change that today. You'll be glad to know. Just in terms of your engagement with other statutory agencies, and I'm well aware there will be a considerable debate over the next number of weeks, subject to the publication of a draft budget, and every department will have concerns, issues around that, and that will take us into a space in the next number of weeks and months. But what sense do you get from other agencies? Because Brian has rightly identified that some of what's being suggested cross-cuts into, for example, the Department of Communities. And has there been any sense from that work that has commenced that the Department of Communities and I'm just taking that one as one example because there's other elements of that you would consult with, that they are willing to consider being prepared to engage with and be involved in trying to get to a point where there's a better outcome for these victims. And let's remember that's what they are. They are victims of the most horrendous crime and the most horrendous set of circumstances. Anybody who has seen any of the footage, the detail, we all can accept that these are terrible circumstances for people to be caught up in. And do you get the sense that other departments are willing to be engaged?
Chair, yes, is a simple answer to that. We have, through the Organised Crime Task Force, a subgroup on modern slavery, human trafficking, and other departments, including Department for the Communities, Department of Health, the Health and Social Care Board, and other bodies such as the GLAA, Border Control, etc., are all part of that. So we have that where we meet on a regular basis and we engage in that. But yes, Department of Communities, just to use that example, is involved in this and also is aware of the issues, and obviously within the constraints of that department, they will have their own policy areas, etc., but they are very aware of it and they are engaged in it. We also have a group, we have a group with the NGOs which we engage with, again on a regular basis, and that provides an opportunity for the majority of those groups who have submitted evidence to you to engage with us and to discuss the issues and to share experiences.
And just another, sorry, Cathy, yes, go ahead.
I was just going to add to that, Chair, just to say that obviously the issues that have been raised by the organisations in response to the clauses and to the committee also gives us an increased urgency to engage on very specific issues. So while we're engaged on a range of issues, there are other things I think that have come through the feedback to the committee in terms of health and universal credit and welfare benefits and things like that that we will probably focus a bit more on as a result of some of the feedback that's gone to the committee. So I think it's been very helpful to get this feedback, and it gives us, I think, more of an impetus to work together.
Yeah,
well, I think it's very clear that, in fact, this is quite a complex sort of issue, and it's about pulling all the different strands together. So that's why when we were saying about actually the importance of actually getting this scoping and getting this right, we do need to take the time to actually bring all the various players together and talk this through, and of course engage in the voluntary community sector as well. So this is a work which the Minister is committed to taking forward, and it's, as Ronnie says, it's taking a bit of preparatory time to get the scoping underway, but it's moving it up, moving into gear in the new year, building on the good work done in the autumn. And this is something which the Minister is seeing as a priority. So it's something which we're seeing as going forward actually at pace once we get started.
And that's helpful, Brian. I think just in terms of the additional information that we've received from some of the NGOs, we'll be quite happy to, with the committee's approval, to forward that to yourselves, because I think it's another component part of the information that comes to us in relation to this. However, if I just go back to one, just so there's clarity around this, if we look at the issue of immigration, that obviously is a Home Office issue, and there are particular arrangements in place in terms of asylum seekers in Northern Ireland. However, Ronnie, is there any discussion? Because I always worry that when you get a difference between who is the lead in terms of a government department on a particular issue, that there's always a tendency that people can fall between those 2 or 3 departments, whatever it is. So there's elements of this that the Home Office would have some responsibility for. There's obviously elements that the department, and then, as we've discussed, it would lead into communities, it would lead into other health and so on. Has there been any, at least, discussion so that we don't blur the lines and everybody knows what the responsibility is between us and the Home Office in some of these matters?
Can I just start off there, then Ronnie will give you the proper answer. No, just, I think, Chair, it's building cross-agency or cross-sectoral mechanisms is always complex, but certainly in the devolved sector, we have good relationships both with the other government departments and also with the voluntary community sectors. So, whereas actually these things aren't without problems, our expectation is that engagement will actually be an enormous part of value in actually pulling together the right solutions. When it comes to dealing with reserved or accepted matters, that is more problematic because we are at a distance from the Home Office. And at the end of the day, Northern Ireland's a population of 1.8 million, in the UK 60 plus million. So to some degree, all we can do is do what we can to be influential, and certainly we can liaise with them and put our points across. And I think it's fair to say we often actually punch above our weight because we have a good understanding of how these things are working on the ground. But certainly there are problems there, and Ronnie, no doubt you can now give us the right answer.
No, that's very helpful, Brian, thank you. No, Chair, we liaise very closely with the Home Office. Obviously, we liaised initially with that part of the Home Office, which their modern slavery unit, and with some of the associated parts of the Home Office in that, and we would have regular meetings. We had we had a meeting this morning with them on some of the implications for the Nationality and Borders Bill for the modern slavery section and that. So we do liaise we are very clear on where the responsibility of the Department of Justice lies, and also where responsibility on the reserve matters that lies with the Executive Office in relation to immigration. But we also liaise with the Executive Office officials in terms of that as well. So it is, I mean, yes, it is quite a complicated framework, but we do have good relationships, and we're able to input and to talk to different parts of the Home Office system and the other devolved administrations, as well as the whole sort of framework of government here.
Yeah, and I think that's useful, Ronnie, in terms of having that assurance that at least there is that discussion with the Home Office, particularly given the implications of the Nationality and Borders Bill and the Clause 53, which would have an impact. But just one other question before we go to members, and that is, I want to seek clarification on this point, and that is, would the extension of the support up to the 12 months require there to be a legislative change, or could the Department use the power in Section 18(9) of the Human Trafficking and Exploitation 2015 Act to ensure the provision of assistance and support for, as it says, for such period as the Department thinks necessary? Brian?
I think the short answer is yes, because essentially the Department has a discretionary power, and as I noted in the opening remarks, we're already finding that typically there's more than 150 days of support. And actually, on the far end, it went up to 500 days. So clearly, this is very much being used that way at the moment. And certainly, that is quite practical. But I don't know, if you want to add to that.
I suppose just in terms of post-conclusive grounds, that is a discretionary power. And at the moment, that does not set a minimum or maximum amount of time that support can be made available. If you wanted to stipulate that it was 365 days, yes, that would require a legislative change.
Yeah, okay.
But it's worth noting that the whole discretion is based on assessed need. So in fact, if the department or its agents are carrying out an assessment and a need is identified, then in fact that's the basis of which that discretionary power is exercised. So you could find presumably a case where someone wouldn't need a whole year's support. Equally, it could, as is obviously the case at the moment, some people are getting considerably more than that. So it is very much based on assessed need.
Yeah,
what we could do, Chair, just to add to that though, is that we could make it clearer what that discretionary power enables us to do, and we could make it clearer by way of a framework or some sort of guidance where we would see that that support being made available, why and to what extent, and whatever, and to make that clearer. So, but we could do that administratively, not necessarily through legislation.
And that be made public.
Yes, Alison, there's something in England and Wales that they have a framework, isn't there, that,
yes,
that
so,
sets it out?
Yeah. In England and Wales, there's a recovery needs assessment which sets out how somebody who's got a conclusive grounds decision might be supported. We don't have a similar process, formal process in Northern Ireland, but as has been reflected, in many cases the department does have the discretion, has used its discretion, and is open to supporting beyond the stipulated period. So we have tried to use 18.9 in a flexible way, and I think it does provide the framework for doing something on a longer term basis.
Okay. Robin, you just want one comment?
Thank the delegation for being with us today. Just a very short comment. If someone was to move within the UK for whatever particular reason, how would the support be affected or improved, or how would it be carried on?
Not aware of details in which, in any cases in which that has happened, but certainly the support providers in Northern Ireland would be liaising with the equivalent support providers, whether in England and Wales or Scotland, to ensure that as long as they're in the NRM, they're entitled to support and they're receiving that support.
I don't know what you were overcome by something there on the. I don't know.
Just something flew past.
Seagulls,
Seagulls.
Seagulls.
So let me just tease that out just a little bit. If a person in Northern Ireland was receiving support from you, and then for whatever reason, which presumably would be a position that would, I don't know whether it was family reasons or for whatever reason they may move to some other part of the UK, then how would the support be continued, or what would you need to do to ensure the support was continued wherever that took place?
I mean, that would essentially be led by our service providers, who are Migrant Help and Belfast and Lisburn Women's Aid. And where there is some sort of transfer between Northern Ireland and another jurisdiction, the support providers would be facilitating that and making sure that that support continues.
Okay, and whatever the conditions applied in Northern Ireland, then they would get in England, Scotland or Wales?
I mean, it's broadly the same framework. There are some slight differences between what's provided in Northern Ireland and elsewhere, but generally as potential victims under the NRM, they're entitled to a minimum level of support, and we would certainly see that that's provided in other, elsewhere in the UK. Yeah.
Okay, thank you. Thank
Yes, so they wouldn't lose their entitlement to support by moving.
Okay, thank you.
Elsewhere in the UK.
Yeah, and just Alison on that, would the reverse be the case? So someone moving from England, Scotland, Wales to Northern Ireland, because they have a formal framework, but we have something that's not just as formal as that.
Yeah, it would work both ways.
Right.
Chair, certainly if somebody was transferring to Northern Ireland, had that entitlement to support, we would certainly put the arrangements in place, yes.
Okay, that.
So that's the NRM's giving you an entitlement. Actually, it would actually be your ticket into getting service, whichever part of the UK you're in, and service providers would facilitate moves. If I conceivably maybe someone might want to move to another jurisdiction to be closer to a family member or something like that, and that would be facilitated.
Yeah, and I suppose, and I just make this because there's other members I want to bring in. There's always an issue if in the subtext of a piece of legislation, which is we're talking about 18.9 of the 2015 Human Trafficking Act, and it's a discretionary. Like, I'm aware of another discretionary power within the Department of Communities, a discretionary waiver that I'm trying at the minute to pursue on the behalf of a constituent. And I have to say, you would probably find the proverbial needle quicker in the haystack, because it seems to be limited in terms of the number of times that it's used, as opposed to the number of people that are affected by, and that's all to do with the benefit system. So I suppose the point that was made is valuable around making this aware that there is, and seeing the detail of the framework, what it looks like, in information terms, and I think that would be very, very useful and be very helpful if that was able to be made available.
Yeah, and Chair, that could be, you know, that's something that we could look at in terms of the scoping exercise. How clear do we need to make that, and what more could we do at an administrative level to make that clearer, and so that people are aware that we do have that enabling provision already?
Okay, thank you. I want to go to members now, and as I have hopefully noted them down in order. Gemma.
Thank you, Chair, and thank you to the officials. I'm going to leave my camera off, if that's okay, because I think my internet connection is a bit dodgy. Okay. So that's from Anna Broadband for you. Well, I have two questions. I'll start with the first one. So Ginny and other stakeholders have recommended amending the bill to introduce slavery and trafficking risk orders alongside slavery and trafficking prevention orders. And the Department also referenced STROs in the 2021 Modern Slavery Strategy. What work has been done on exploring STROs? Why has this not been included in the bill? And would you be open to exploring an amendment on this issue?
Well, the work on I can't speak for why it wasn't included in the bill, but certainly a lot of the consultation work has yet to be done. There has to be a consultation exercise on it. We have prepared the papers, and they will actually be coming forward to the committee after Christmas in terms of looking at duty to notify and STR, and which is the activation of the powers and duty to notify in the 2015 Act, but also the introduction of STROs. So we're going to go forward with a public consultation on it. It will be then up to finding a suitable legislative vehicle, probably in the new mandate, in order to take that forward.
Now, I might add, as obviously the bill manager, as I know I've said a few times previously, producing something which goes into legislation typically takes a year from start to finish to get to the point where it's being drafted into legislation. We were very clear this time. What happened was I suppose all of the trafficking and victims material could have been left in the next mandate and produced as a single bit of legislation. However, we had the opportunity to put some elements in which could be done at a reasonable pace and get into this bill. And rather than hold them back to wait for everything else to catch up, that's the approach we took. However, taking the risk orders forward, it requires consultation. It was new policy. The policy wasn't resolved. This required a process. So here and in a number of other areas, we recognised we needed to undertake some scoping work. This would take time. It was not feasible to get that done in time to get this into this bill. So rather than actually hold back a couple of provisions which we were ready to take forward, we felt it's important to put in the elements which we were able to progress now and give commitments to take a fuller approach as we go into the next mandate, with a view to actually pulling in either a bill or a section of a bill which will pick up all the outstanding issues.
Okay, that's fair enough. That answers that question. The second and final question is, the UN Special Rapporteur recently issued advice on the non-punishment principle, and others have also recommended that the statutory defence is reviewed to protect all victims, including people convicted of offences related to Class A drugs. Has the Department any intention of reviewing the statutory defence?
Yeah, so the team has started gathering evidence to inform the review in terms of relevant judgments. The Independent Anti-Slavery Commissioner has also produced a report, and there's a lot of research. So we've started that work. I think it's fair to say it's a very complex area, and it's one that it's very important to get right, because the defence, it protects victims of modern slavery, but at the same time, we have to be very careful that it's not open to any form of abuse. And some of those issues were reflected on in the Independent Anti-Slavery Commissioner's report. So certainly we want to look at all aspects of it as part of the review, including whether it should be amended, adapted or changed in any way. Okay,
thank you. Yeah, I understand that. Thanks very much.
Thanks, Gemma. Brian, can I just clarify something following on from that question, the first question that Gemma asked? Are you saying, is it then the case that an amendment to introduce the risk orders to this bill could potentially not be admissible because it might not be competent with the legislation because it hadn't been consulted on. Is that?
Well, what I'm saying is Chairman, this is a complex area. Just saying we'll have a risk order in a provision without actually having developed a policy and understanding, having gone through that consultation process, having listened to the various stakeholders to get their views about what needed to be in it and how it should operate. So that's part of the policy process. And what I'm just saying is the department has not got to that stage yet. And we would see this, therefore, as part of the broader bit of work to be taken forward. Now, of course, you can put something in. What I'm saying now is what I've said to the committee sometimes in the past, that it's important we develop good law. And our process is traditionally that we will actually develop a policy, we will do, and I've gone through many pre-consultations, which is what he's been doing on that last question you raised. Yeah, I've gone through many pre-consultations to prepare the way for consultation. And that process of pre-consultation, consultation, reporting, decision-making, all precedes us writing instructions for legislation. That's why it takes time. What I'm just saying is, in fact, that we are not at that stage at this point. And we feel, the Department and the Minister feel it's important that where you're developing major new policies, we actually go through the full process, so we give NGOs and others the opportunity both to actually give us the initial advice, but also to see our proposals in a consultation, and then allow the Minister to benefit from their responses in developing her decisions. So that's the process. What I'm just saying to you is, of course, you could put in an amendment which I'm sure would be in scope. But at the same time, I'm just advocating that we should do this in an ordered and structured way as part of a broader bit of work, because ultimately it'll produce a better outcome in law. Thank you. Sinead?
Thank you, Chair, and thanks to Brian and team for presenting to us today. And I have to, I suppose, your opening comments in terms of Cathy, having heard the presentations to committee, and they have been quite widespread in terms of the support to victims of trafficking. And I'm hearing from you today, I suppose that you have heard that and you have an open mind to working through some of that. But I'm also hearing, Brian, as the previous point, I suppose, proves, that you've already, I suppose, decided that there are things that have been raised that you are setting aside as not fitting, perhaps not that they're not in scope, but you see that there wouldn't be the background work to support what it says on the face of the bill. And then you would be, I suppose, reversing into having something on the face of the bill and then going into a period of consultation and building up what that actually means. But that said, it is disappointing because the argument for SCROs was very clearly made and forcefully and correctly, I think. But in terms of the support for victims, we have heard, right through from their status, whether they're in a period of, even if their status is being questioned or they're questioning that, and access to secure home and income, access to GP and health, the whole piece about being able to reunite with families, and I appreciate that's not something that has to be in the face of the bill, but it's something that we should at least be visiting in terms of, trying to be sincere in our safeguarding piece. And the expunging of convictions is another major piece. But if I would also go back to the fact that we talked about whether support around a victim would transfer with them, and it's right that it should across all jurisdictions. But I'm also aware that any victim will be known to an unsavoury network of people. And if that victim happens to be on this island, is there any consideration given to the fact that if they cross the border, that they cannot become somehow lost and re-trafficked? So I just would like to hear your thoughts on that. And I appreciate, that this is us trying to put a lot on to a bill that has fallen short on a lot of areas. But I want to know realistically then, in terms of the department making assessments on what they do hope to add and what they think they cannot add, When can the committee be made aware of that? Because we will have a very short window of time left as a committee to see, can we pick up any of the threads that the department are not able to follow in terms of then amendments? Thank you.
I think to start with, the Minister, at the time this bill was first laid, and we spoke to the committee about this, she indicated there were a number of areas where she was preparing amendments which were already well underway, and in, I think, most cases had actually been consulted upon. And there were 3 or 4 areas where she was proposing to put amendments in. And those, I think the committee has got either, I'm not sure if you've got all of them, it might still be one outstanding one. You may have all, like I've lost track of the last one. But certainly, the department isn't proposing to add any additional amendments other than the ones which we agreed with the committee, obviously related to the Stalking Bill. It's a different bill. So essentially what I was saying there was the whole approach to trafficking victims is a journey in the sense that we've had the opportunity to put a couple of clauses into this bill now, which actually we feel will be helpful, particularly in terms of supporting victims and also actually getting the strategic period in a more sensible one. But this is only the first stage in what's a much bigger process. And the thing is, we are not at the point where we have all the information. We're not at the point where we've consulted all the relevant players. We've talked through options. We've discussed the different variations which are possible. And what I'm saying to the committee is just, in fact, this was as far as the Minister and the Department could go at this point. But what we have got is a mechanism. We've now got a dedicated team looking at this, and that will actually help enormously. This is about going forward and trying to squeeze odd bits into a bill which the current bill. I think it would be a dangerous tactic because as you say, can't consult. Once the law is the law, once it's in the bill, it becomes the law. We can't have a post hoc consultation to see whether the law is right, So you end up having to change the law, but you would end up in the wrong place. So what I'm saying to the committee is actually that the Minister is committed to pushing this forward. We've now got a dedicated team to deliver this. The wheels are now turning, and we're moving in a number of areas. The risk orders are just one of those areas that we'll be moving in. The Minister is quite clear that she believes, like the committee, that these make good sense and are important. The Minister's also been very clear that we need to make sure we give appropriate and effective support to victims. So those are the background issues which have predicated the way we've approached. And what I'm cautioning the committee that just picking up a good idea and putting it into a provision in itself at this stage isn't necessarily the best way ultimately in supporting victims of this pernicious offence.
Yeah, Brian, could I just maybe say there, I suppose what I'm alluding to is the fact that I appreciate a lot may not present on the face of the bill, but there have been really good points raised by stakeholders, and there could be actions that happen as a result of that being brought to light that don't necessarily mean being on the bill. For example, that whole reuniting of families piece, that's something that needs and could be acted on, and we as a committee no doubt can put pressure to that. And also that north-south piece is sitting uncomfortably with me at the moment. If anybody has anything to offer on that, I'd appreciate hearing.
I'll pass you over to Cathy, but I think you're absolutely right. There are a number of Cathy and her team will be listening and look very carefully at all the evidence you've got, and that won't be wasted. It's advising you, but it will also advise the work going forward. And certainly that's doable. And there's also a number of administrative things which can be done which don't require legislation. And then clearly that team will also look at that. But I'll pass you over to Cathy, who will say more on that.
She did, absolutely. I mean, we will reflect on everything that we have heard and that has been presented to the committee. If we are able to move into a longer term strategic approach, instead of 1 year, we go into a 3-year strategy. That enables us to do that engagement and consultation with stakeholders. In terms of the STROs, Ronnie indicated, we hope to go out after Christmas with a consultation on STROs and then find an appropriate legislative vehicle as soon as possible in the next mandate, depending on what the outcome of the consultation is, and that's the same then with the duty to notify. So a lot of what came through in the responses to the committee also came through in the responses to this year's modern slavery strategy, and is also included in the Sagini recommendations. So we have a building picture of things that need to be taken forward, and we are absolutely committed to doing that. But I think we need to think through some of the implications, and even the Sagini recommendation about STROs was to re-examine the need for STROs, and we want to look at that in terms of what are the benefits and what are the implications. By simply putting it into the bill at this point, I think we won't have had time to think through the potential implications of that.
No, I appreciate that, and I can see how there could be some quite dark implications if it's not played right. So yeah, I appreciate that. Thank you.
In terms of STROs, just by way of a bit of additional background, they were originally consulted on back in 2013-14 when the Northern Ireland legislation was being developed. And some of the respondents at that time raised concerns around human rights implications and the fact that these orders might well apply to individuals who hadn't been convicted of any offence. And I think for that reason, we would want to be quite careful and would want to take the mind of the public through consultation to see if that sort of message still stands. So that's why we think consultation would be helpful in that regard. In terms of the cross-border piece, I think at operational level between the police and the Garda, there certainly seem to be very good working relationships. The Garda attends some of our organised crime task force meetings in respect of modern slavery and human trafficking, and you'll probably also be aware of the Joint Agency Task Force, which brings together law enforcement from both sides of the border. Modern slavery and human trafficking is one of their key focus areas, so I think there is, on a cross-border basis, that element of attention.
Initially, we've set up, we have established relationships with the Department of Justice in the Republic as well in terms of their modern slavery. So from a policy and legislation point of view, we do have a sort of developing a closer relationship with them on that.
Okay, thank you, Sinead.
Thank you. Thank you.
Thank you. Just following off on that point about Sinead in relation to the SPO or the STO. The Sagini report in 2020 actually made it very clear when they said that the report includes some evidence of examples from England and Wales of the beneficial use of STROs in cases where there are protracted investigations, i.e. applying for an STRO before a prosecution might be brought. And they went on to say, these civil offending, then Sagini recommended that the Department of Justice, in consultation with the Police Service of Northern Ireland, the Public Prosecution Service for Northern Ireland, and after consideration of the experience in England and Wales, should re-examine the need for slavery and trafficking risk orders in Northern Ireland to prevent modern slavery, human trafficking, related crime and support victims within 1 year of the publication of this report. But now, Brian, what you are saying is, no, we're going to go out to public consultation. That will take us to the end of next year, at least, and we have a situation, and that's a consultation with the public. But do we know at this minute in time what the department has done in relation to speaking to the Police Service of Northern Ireland and the PPS in Northern Ireland and taking on board the experience of England and Wales?
I'll pass to Ronnie 1 second. I'll just note a consultation, if it's going to go out in January, will be 8 weeks, well, usually 8 weeks, sometimes they stretch an extra week. It would often, although I know it depends on the complexity, but in fact normally the Minister will take a decision within a month or two of that. It varies a wee bit, I accept. It's certainly not a year's process, and certainly because this has actually been given priority, I don't see that being.
Yeah, but Brian, let's cut to the chase here. Purda's coming. There's an election at some stage. This is going to be kicked into the long grass, and this will not be revisited in real terms until at least after Easter. You know, that's the reality of this, and that will be a year. That will be outside the time frame of Sir Ginny, which has said there should be work done on this in terms of the police and the PPS. And I just want to know, what work have we done, the department done, in relation to establishing from the police and the PPS the benefits of these orders? But
Chair, the issue of STROs has been discussed. We have regular contact with, we have discussions with the police, both police and the PPS, and it has been discussed in quite a lot of detail with them, and that has led, if you like, the foundation for us then going out to a public consultation on it, because we do see that there is merit in looking at the introduction of these. I mean, the time frame has slipped a bit because, as it was said earlier, the pressures of other things, and then with setting up the new team is taking that forward, and that's what, that's why we feel we're able to go forward. And more, we will be able to keep the pressure on in terms of the consultation. We would. Once we accept that we may run into PERDA, etc., that's not something of our gift, as it were, but we have to keep going, and we will keep keeping going to work through that, so that in a new mandate we would be looking to come forward as soon as we possibly could with those provisions.
Chair, could I just add that in response to the Sir recommendations, the department didn't indicate that it would be able to meet that time frame, and that we actually said that that will be taken through in the 2021-22 modern slavery strategy, and that, you know, the finalising it will be taken through in that. So we didn't say that we would be able to meet that time frame, and actually did indicate that that would probably need a longer time frame to bring in STROs.
Okay, thank you. Rachel.
Thank you, Chair. Thank you, everybody, for attending today, for your answers so far. There's been a lot covered already, but I just want to get a few points of clarity, and apologies if there's lots of beeping that goes on in the background. My smoke alarm is beeping and I can't reach it because I don't have a ladder in the office, so that's what it is. It's okay.
You're all right.
No, it's not a seagull, but it is incredibly annoying, so apologies on that. I just want to take you back, I hate pressing on with these STROs, but I just want to clarify, there was a comment made there that STROs actually have been consulted on in 2014, is that correct?
It was before the 2015 legislation was introduced, so it was either 2013 or 14, and we can confirm that subsequently if that is helpful. Okay. But it was part of the package of measures that were consulted on prior to the 2015 Act being introduced.
Okay, thank you. And the reason why, just to so I can get my kind of thoughts straight, the reason why we don't want, obviously looking at it in this bill, but for future mandate, is because we want to go out and basically check public mood on this. There was human rights issues with regard to them applying to people who may or may not have been convicted. Bearing in mind that committee has just been looking at stalking protection orders, which actually don't require criminal convictions as well. So is it the same human rights issues that we're looking at on those ones as it would have been on the STROs?
I think it's fair to say that our thinking on STROs has developed. I suppose our preferred approach would be to consult if we could.
Okay, that's fine. Just to get that. And the work that's going forward as well on the duty to notify, that's already in legislation. You're just consulting again to, is it sort of a direction of travel, or is it to commence those regulations that are in 2015 legislation?
Yes, Rachel, it would just be activating the provision that's in the 2015 Act. Yeah. Okay.
Thank you for that. I just wanted to clarify those things. And I take back again on what's already been covered. This is a section that was brought up just quite a lot, and that was on the Section 18.9 of the Human Trafficking Act 2015, and that is on the assistance and the discretionary nature of the support. And I appreciate the answers given so far on that there might be actually something that we don't need to do in legislation. Actually, it might just be clarification of guidance or additional frameworks or so on to make it explicit. Could that extend to those who are appealing a negative decision?
It doesn't currently at this time. So the parameters within which the department provides support are that an individual is in the NRM or about to be referred into the NRM, or they have a positive conclusive grounds decision. So that's how the legislation is set out at present.
So to cover so somebody gets a decision and they want to appeal it, to cover that instance, to continue the discretionary support, that would require legislative change?
It most likely would, where it's a negative decision, yeah.
Okay.
But again, that's something that we could look at whenever we're looking at the extended support. You know, whenever we're spending more time and focus on this, that is an issue that we could, you know, look at and say, well, if it doesn't go into legislation at this point, that would not preclude us from, at some point, if we thought it needed to, you know, or if there was a general need to. But we could also look at whether those who are currently appealing could be included in some of the framework. So it wouldn't prevent, the fact that it's not in legislation might not prevent us from doing it, but we'd need to think that through. That's another example of where we need to think through what are the implications of setting this out now in legislation without having that opportunity to think through the potential benefits and implications of some of the issues that have been raised. Rightly raised, I think, you know, in terms of what organisations want to happen and the support needs, and increasing and enhancing support is a key action in the strategy, in the modern delivery strategy. So it's something that we do need to look at.
No, definitely. And I appreciate it's trying to encompass quite a lot here, but if there's a discretionary power there, surely the discretionary power could be applied in a discretionary way to cover people who are going through an appeals process, but perhaps that's a policy or a guidance document or that kind of thing, because if the power is in itself discretionary, it could then be argued that it covers that. It might not be explicit on that, or would that sort of require something to change in the 2015 legislation?
I think I'd need a lawyer with me to answer that question.
I wish I was one. Unfortunately, I need one myself. If you've any floating around, I would take one. But just if there would be any information on that, it would be very helpful, because that certainly came in through loud and clear through a number of the submissions that the committee got. And certainly, if we have a very small number of people that are going through an appeals process, surely that discretionary power, yes, it might not be explicit, but because it's not, doesn't mean that it can't be done or used as a reason not to. So no, thank you. I'd appreciate some information on that. I suppose then as well, on a similar theme of support, has there been any engagement with health with regard to access to healthcare and extending healthcare entitlement so far?
Yeah, we have. The issues which have been raised with the committee by some of the NGOs, we've also they've also raised them with us, and we've been looking at those. And there is the provision of healthcare, obviously, as you say, does fall to the Department of Health, and we have been talking to them about that. But at this point in time, we haven't come to the Department of Health has that responsibility, and we haven't sought to change that, if I can put it like that, at this point in time. But it is an issue which we are aware of, the healthcare provisions. Again, it's one of that we have provided assistance under Section 18 in terms of healthcare in individual cases, depending on the individual circumstances. But it is not a blanket provision of assistance that we have provided.
No, thank you. Appreciate that.
This again, on a case, it would be on a case-by-case basis, and it would be. I think certainly in my time, it's only been one or two cases, maybe that in terms of the support contracts through the support contracts with our support providers.
Great, thank you.
Rachel, is this in terms of specifically anyone who is appealing?
Well, that and also those with a negative NRM. But so if we have a case where somebody has a negative NRM and then is appealing, what's there for them? and because it's not covered explicitly. And I suppose that's where I was kind of going with that, with those that we were hearing from, and in terms of that, is there a discussion with Health to Health to say no, we can't do it, or what's the practical implications of that? But I appreciate it is the Department of Health, and I'm not in any way saying that there hasn't been support. It's just obviously it's not explicit in front of us, and it has been raised as an issue, and obviously we looked at and heard evidence at committee about the 2015 Act and the way the Scottish legislation differs, and that's a wee bit more substantive in terms of healthcare. So that's sort of where the question was coming from. The only other thing that I have that I don't believe it's been covered, and apologies, I do get distracted with this incessant beeping in the background. The expunging of convictions, and that was our understanding in the Republic of Ireland. The Minister for Justice there had made an announcement to expunge convictions through no fault of their own for over 600 women for prostitute-related offences. Do you know, or has there been any conversations within the department about this, about looking at this, or if there would be any intention on the Minister making anything similar?
Well, that actually falls into my area of responsibilities, luckily enough. The truth is we are in communication with the Department of Justice in the South. What the Minister said is actually not that she'll legislate. I think she's expressed an intention, or they've expressed an intention to in essence, initiate a legislative process. So they're actually carrying out a review at the moment. And now, obviously, they've sloped the pitch a bit as far as the expectation at the end of the review they will change the legislation. The Minister, and I think from our perspective, we certainly, the Minister would see this as being a reasonable approach. And certainly our direction of travel, I suspect, may well be the same. But in fact, my expectation is we get into the new year, we will actually review this ourselves. Working with our colleagues in the South just to see what they're coming up with. In essence, looking at it though, certainly on the prostitution side, for example, we were looking, I had a quick look to see when the most recent conviction was, and I think it was 2004. Okay. So, 17 years ago. So to some degree, a lot of these cases are quite historic. Now, ultimately, the legislation does allow where people are, and Kathy will know much more about this than I do, the current legislation allows for the fact that where someone is forced to commit an offence, that they won't be prosecuted. So, and of course, prostitution is no longer a criminal act in itself anyway, since 2015. So there will certainly be a number of cases, might be as many as 50 historically going back. But certainly it's a small number of cases, they're quite historical. And in some ways, I think this is one which is probably the right thing to do, and I think that's the Minister's approach. But I think the aim will be for us to carry out some sort of more detailed review, take on board what's happening elsewhere, and then from that make proposals for going forward. And that could well be a legislative change, but certainly the legislation will probably not have a massive amount of impact, certainly on prostitution, given the historical nature of the cases. So it's something which would be like a number of other areas, something where you can fit them into a bill, that would be something you would do. But it probably wouldn't be a priority in the sense we haven't got any strong sense that there are women presently being seriously affected by this, although clearly if we do a review we'll get evidence from others, and if we do hear of cases, then that would change the picture.
Great, Bren, thank you. You answered my follow-up questions if you had any numbers, so you're fine. Thank you so much for that. Thank you, Chair.
Thank you, Rachel. And just maybe to conclude, Brian and your colleagues, in relation to the whole reporting regime, what is currently in place by the department to be able to gather information, monitor the arrangements that are in place, and identify the trends and inform the future policy and the legislative decision? Because obviously this is a major piece of work, and currently what are those arrangements that are, if they are in place, within the department?
So currently, each year when the modern slavery strategy is produced, there's also an update on progress against the actions in the previous year. We also issue under the Organised Crime Task Force an annual threat assessment, and it also details the disruptions that have happened, and modern slavery and human trafficking is included in that. So we do have ways in which we report on progress, but we do understand that moving from an annual strategy to a 3-year strategy, people want to see built into the legislation, I think, a requirement to produce an annual report, and I think we would be content that that's a reasonable request, because we want to maintain the transparency around the progress and the updates, and we also want to get buy-in and increase the communication around modern slavery and human trafficking out in the public as well. So annual reports and annual threat assessments and updates on disruptions and things like that also help to raise this issue of modern slavery and human trafficking, which is a key action for us and for all of our partners.
Okay, thank you for that, Cathy. And can I just thank Brian, Ronnie, Alison and Cathy for their attendance today. And as Brian said, I think last week, no doubt he'll still be part of the committee over the next number of weeks and into 2022. But in the meantime, can I just thank you for your time that you've given to us this afternoon, and appreciate what you have provided for us. Thank you.
Thank you.
Thank you. Okay, members, can we then return to the previous item, because I understand that the Minister is able to be with us, and that's to item 4 in terms of the stocktake of the policing oversight and accountability arrangements and the Police Ombudsman's 5-year review, and in terms of the proposed legislation. And just to remind members of the committee that you'll find that information at pages 66 to 250 of today's meeting pack, and also to advise members that the consultation document outlines the proposals for change identified through the stocktake and the groups and the Ombudsman's recommendation into those that may achieve consensus and could be taken forward, and those that are unlikely to achieve consensus and therefore should not be taken forward at this time. Can I welcome the Minister to the committee meeting? I'm glad that she has got released from the executive. I'm sure she'll be glad of that. And also, can I welcome Maura Campbell, the Deputy Director and Head of Policing Policy and Strategy Division, and Lisa Bowl, the Policing Policy and Strategy Division. And I think maybe Cathy is maybe going to move over from the previous meeting, maybe into this one, maybe not. But can I just welcome you all to the committee? Minister, if you want to make a few opening comments, and then no doubt members will have questions. Thank you.
Yeah, well, thank you very much, Chair. I did reflect to the previous Chair, who was of course chairing executive, that it was a delight to be released from one of you to meet with the other. So I'm glad that I've been able to make it along this afternoon, and thanks to the committee for accommodating the shift in times. I do appreciate that. I just really appreciate also the opportunity just to brief members today on the forthcoming consultation on the stocktake of policing oversight and accountability on the powers of the Police Ombudsman. I'm going to keep my introductory remarks pretty brief, because I would like to allow more time for members' questions, because I realise that they may have issues which they wish to raise. Last month obviously marked the 20-year mark since the establishment of the Police Service of Northern Ireland and the Policing Board, and last year we marked 10 years since the devolution of policing and justice powers to the Assembly. When I became Minister of Justice, I thought it was timely and good practice to take stock of the current policing oversight arrangements to see if there were any areas that needed improvement or reform. I've also received recommendations from the Police Ombudsman herself for reform of her powers, and I'm taking the opportunity to consult on her 5-year review report alongside the stocktake. In Northern Ireland, as you will be well aware, a number of bodies have a role in ensuring oversight and accountability of policing, which is a fundamental part of ensuring and promoting public confidence in the service. The principle of independent oversight and accountability is now widely accepted and supported, and the arrangements have been broadly working well since they first came into being 20 years ago. There have been many changes, however, in Northern Ireland over the last 20 years, and of course there will continue to be new challenges that emerge in the future. So it remains vitally important to have effective oversight arrangements and also ensure that they remain fit for purpose as the demands of a modern policing service evolve. The principle of independent oversight was central to the Stocktake, and we've endeavoured to work with the various bodies carrying it out. We engaged with each of the oversight bodies, including the full membership of the Policing Board, and with the bodies representing both serving and former police officers and police staff. I want to put on record, if I may, my thanks to all of those who took part in the discussions. They were really constructive and also provided us with some valuable feedback, which we've sought to reflect in the proposals being put forward. The engagement to date has confirmed that the existing architecture for policing oversight and accountability is still generally seen as being fit for purpose. It also reaffirmed the important role of the Policing Board with its mix of political and independent members in ensuring an effective, representative and accountable police service, holding the Chief Constable to account. I acknowledge there are differing perspectives on the extent of the Police Ombudsman's powers and what they should be. But again, I've welcomed the opportunity to discuss these with stakeholders and am keen to identify recommendations on which we can reach consensus. In the consultation paper, we've set out the various issues raised during the Stocktake, with the work that's already in progress to address some of these and the additional actions we're proposing. The papers we have provided to the committee set out the detail of the range of issues raised, which include clarity of roles, ensuring complementarity and good coordination in respective inspection and review arrangements, and governance and financial management issues. The nature of our oversight arrangements and the respective responsibilities of each of the bodies means that some of the proposed actions will fall to other bodies to take forward, in some cases with the support of the department. Many of the proposals are operational or administrative in nature, and most would not require legislative change. Turning to the Ombudsman's proposal specifically, I'm conscious of divided opinion that can arise on aspects of the Ombudsman's work, as was expressed very clearly, I think, in the debate at the Assembly Chamber on the 18th of October. Nonetheless, it is important that we consider carefully the case for reform. Oponi's powers have remained unchanged since 1998, and we should consider carefully the need for change in light of 20 years of learning and to ensure into the future that the office remains fit for purpose. We're awaiting clarity on the government's plans for legacy investigations, and as you know, that hasn't been forthcoming to date. However, it is expected that Oponi will no longer deal with cases that predate 1998, and so we should consider the proposals, I think, in that context. I believe there's merit in looking at the proposals with a view to progressing change, including those aimed at making the complaints process more efficient and effective and also more transparent. Our engagement to date and also the meetings the Ombudsman herself has undertaken have given us some sense of the recommendations that could attract consensus, and we've put those forward in the consultation document to test that thinking. However, we're also seeking views on the other proposals in case a consensus does emerge where perhaps we hadn't anticipated. We're aiming to launch the consultation next week and for it to run until mid-February. We'll then need some time, as you'll appreciate, to analyse the responses and consider the issues raised. So it will therefore really be for the next Assembly mandate before any legislation would be brought forward, and that will obviously be subject to the normal scrutiny processes, including with the committee. Finally, I understand that earlier in your meeting there was a query just about the purpose of today's discussion and whether the committee was being formally asked to approve the consultation document, and I think it's possibly worth me just kind of clarifying that at the outset. As the clerk had said, officials had attended previously to brief the committee on the purpose and scope of the Stocktake and how we were handling the Police Ombudsman's 5-year review report on her powers, but that was a number of months ago. In fact, it was February of this year. They indicated at the time that I intended to meet with the committee at a suitable point to discuss what we would do. And since then, I've been engaging with stakeholders, and given the committee is, of course, a key stakeholder, I want to engage with you as well before we actually press go on the consultation. There is no formal or statutory requirement, as you know, to seek approval before launching a consultation from the committee, but I am keen to ensure that the committee is content with the overall direction of the consultation and also have the opportunity to flag any queries or concerns about the content of the consultation with me ahead of it going live. It will be, as I explained, the next Assembly mandate before legislation could be brought forward to give effect to the outcome of the consultation, though there may be some changes that could be implemented administratively, and therefore the committee would be involved at least and kept aware of where that was happening. As I've said, Mr Chairman, I'm committed to working collaboratively and constructively with the committee, and so I think attendance today is an important part of that, and I'm happy to take questions from members about the consultation if they have any.
Thank you, Minister, and we will take questions from members in a moment. Can I just maybe raise a couple of issues? One is this matter around the consultation on the principle of a separate police covenant for Northern Ireland, which has, I suppose, distinct provisions in relation to Northern Ireland, or would have distinct provisions in relation to Northern Ireland. And do you think that if such a covenant was in place, that it would have prevented the very sad situation that we saw played out in our TV screens in relation to the 2 police officers in the Ormer Road? And subsequently, the PPS is telling us this week that they weren't going to forward into prosecutions.
Well, I mean, I think you will appreciate, Chair, that it would be inappropriate for me to comment on individual cases, and I think given the independence of policing is, and indeed of the Ombudsman's office, is the primary concern, it wouldn't be appropriate for me to second guess. There is due process involved, so when complaints are forwarded to the Ombudsman in a general sense, the Ombudsman will go through those, will look to see whether there is anything that necessitates being referred to the PPS. The PPS will then do their job and decide on whether there's anything worthy of prosecution. But I think it's important to note that I don't control either the decision-making of the PPS, the decision-making of the Ombudsman's office, or the complaints process on the way through that. However, I would hope that it would continue to be an open and transparent process, so that those who are involved in it, whether as complainants or as those who are complained about, would continue to have confidence that they're treated with dignity and with respect, which I think was reflected in recent surveys, but also that they're kept abreast of what is happening with any complaint that has been made and how it's being progressed. I think that it's about, I suppose, making sure the process is correct, but I think it would go beyond my office and my responsibilities to start interfering in individual cases or trying to comment or create commentary on around how they should have been handled.
Following on from that, in terms of, just for clarity, am I correct in saying that the decision now has been taken by yourself not to pursue the Ombudsman's proposal on the powers to compel police officers, which would obviously, I would take a view that it would disproportionately impact on retired officers and obviously have an impact on the whole issue of legacy? So are we clear that that now is not going to form part of the consultation?
Well, I think, as I discussed, one of the issues in terms of compelling witnesses is a contentious proposal. I think that's one of the things we'll acknowledge straight away, particularly in relation to legacy investigations. The Ombudsman obviously considers it necessary to ensure cooperation with their investigations, but I've also listened to the concerns that have been, for example, expressed by the Northern Ireland Retired Police Officers Association, that, for example, retired officers lack access to contemporary records and other forms of support that would be available to serving officers who were under investigation. The proposed new arrangements for legacy investigations have included transferring opponents' legacy cases to a new body. So I think that could impact on consideration of this particular proposal. And whilst we aren't clear at the moment how those proposals will be taken forward, I think given both its contentious nature and also the fact that the issue around legacy is a shifting piece of work, it's not something that we would be able or it would be appropriate to take forward at this time, even if we were to test opinion on the matter. I don't think it's one where we would find consensus, and I also don't think it's one that, without certainty around legacy, there would be an issue. Obviously, the compelling of witnesses and so on is a slightly different situation in terms of officers who are currently serving, and it tends to be more contentious in the context of legacy. And I have listened very carefully to what the Northern Ireland Retired Police Officers Association have said in that regard.
And just finally from me, so we can get get to members. You rightly raised the issue of the debate that had been held in the Assembly back on the 18th of October, when concern had been raised about the operation of the Ombudsman. And I've been very clear since I've taken up this role to ensure that we do draw, as best as we possibly can, a distinction between what is our responsibilities here in the Justice Committee and that of the Policing Board, and that's why we have set up arrangements to have meetings between the chairs, vice chairs of both the board and the Justice Committee. And I think that that's for efficiency and for effectiveness reasons. But obviously, the department's consulting on the proposals that the PSNI be under an obligation to respond to the Ombudsman within a statutory time limit. And so, given those concerns, and given concerns such as the Ombudsman's office taking up to 14, 15 years to do a particular investigation, when are we going to actually have in place a scrutiny of the efficiency and effectiveness of the Ombudsman's office, that it's not just seen as an organisation that can take as long as it wants and is not scrutinised in terms of the way in which it does its business, the same as any other non-departmental government body or any department of the Assembly, or the government, sorry.
Well, I think, as I said in the debate, Chair, I think that the office itself routinely monitors case progress and sets targets for completion. So, I mean, they are not certainly oblivious to the criticism, nor do they feel that they are unaccountable in that sense, that they are publicly accountable for the use of public money. In 2020, which is the most recent year for which data is available, they completed 63 of their Category B cases within 110 working days against a target of 70%. For Category C cases, it completed 93 of Category C cases within 90 working days against a target of 85%. Now, those relating to historic cases and legacy cases, by their very nature, could take much longer to conclude, though there are factors often outside the Ombudsman's control that lead to those delays. So, for example, if a file is sent to the PPS, the office has to then await an outcome from the PPS consideration before they can then proceed with further investigation. And some cases have, of course, taken a very long time. I am by no means diminishing the significance or sensitivity of those cases to those both who have been complained about and those who have made the complaints, because often they are the most complex and sensitive cases that the Ombudsman will deal with. However, it would be fair to say that those are the exception rather than the rule. And so it is important, of course, that we try to deal with all cases in a timely way, and that the Ombudsman is able to do that and report on those statistics and allow scrutiny of those facts. But I think it's also important that we recognise the impact that legacy and historic cases have on those timelines. I have been very clear, Chair, that from my perspective, I simply don't believe that the current justice system, including the Ombudsman's Office, the PSNI, the Department of Justice, Legacy Investigation Branch and everything else, I just don't believe that in the main they are constructed in a way and funded in a way that allows us to do justice to legacy cases. I can't be more clear than that. The current system is failing everyone involved in those cases. What I want to see is a comprehensive approach that is properly funded, but that takes this pressure off the modern day justice system so that we can get on policing the here and now and immediately preceding events, and allow another system to take over those legacy cases, which are much longer, more complicated and more resource intensive. Because I think at the moment there is a genuine pressure between legacy and current cases in the justice system, and it's something that I think is to the detriment of everyone who is seeking resolution of their cases, whether it be in the courts, in inquests or anything else. And I think it's really important to put that on record with respect to the Ombudsman's Office as well. It is also important that whilst we don't interfere with the Ombudsman's Office when it comes to issues, for example, of the decisions they make. It's important that those are entirely independent. We do hold the Ombudsman, as we would hold any other body, accountable for their use of public funds and for the fact that they need to be efficient in discharging their statutory functions. So it's not an unaccountable office in the sense that no one ever asks questions. We have our annual meet up with them, our accountability meetings and so on, as we would with any other group. But we don't interfere, if you like, with the operational decisions of the office. And that's an important distinction that we have to maintain in order that the office has credibility, because there will be a lot of people who would want to think that I, as a politician, or indeed any other politician in the Assembly, had any direct impact on the decisions that are being made. And I think it's absolutely right that we keep that separate.
And would that not, if that is the case, and in terms of the openness and transparency piece, would one way of going, because I still think that there's a mist around how the various component parts of all of this does hold the Ombudsman to account, and would one way of doing that be to extend the role of the external independent assessor of complaints against the Ombudsman to substantive matters and not just those involving maladministration? And maybe would that lead you to believe that this could negate the cost and the delays, particularly of retired officers seeking judicial reviews to challenge the findings? And that might be one way of adding to confidence that this body, this organisation, is not just able to continue on without there being some external evaluation and assessment of the way that it goes about its business.
Well, I think you Chair, have hit on two issues. There's about how it does its business, and then there's the business that it does. The business that it does as an Ombudsman's office has to be independent, and therefore it is right that they do that independently. And it is also right that it is for the judiciary, ultimately through a judicial review, if there is a challenge in terms of what is decided by the Ombudsman's office, because otherwise you end up with oversight for the overseer, and you end up with layers and layers actually of bureaucracy, because then who oversees the overseer? So at some point with an Ombudsman's office you have to accept that that is the top of the chain, and if people want to go beyond that, it then gets into the court system. In terms of how they do their work, however, I agree that there needs to be that oversight. So that's one of the reasons why we are looking at that additional oversight in terms of maladministration, for example. It is correct that if things have not been done correctly, there should be a body overseeing that, because that provides confidence. Also, Criminal Justice Inspection NI also inspects the Office of the Police Ombudsman. So there is that power under Section 46 of the Justice Northern Ireland Act 2002 for them to go in and do an inspection of any individual aspect of a pony's work. So I think that from that perspective, it's important that we don't talk about the Ombudsman in the sorts of terms that suggest that it is above scrutiny. It most certainly isn't above scrutiny, nor, and I wouldn't want to speak on the Ombudsman's behalf, but nor do I believe that the office would wish to be above scrutiny, because part of the role that they fulfil is trying to build confidence, both in their own role and responsibilities, and then further on the police more generally. I think in terms of Sujini, it's something that they are able to do. I think that is a good balance, but ultimately when the Ombudsman reaches decisions, I think it is appropriate that at some point then it has to be about, well, if the decision is fundamentally challengeable in law, that's where it needs to then head, because otherwise I think we would just be entering into more layers of bureaucracy. So scrutiny over how they do their job, scrutiny over how the office is run, all of that is absolutely legitimate, but I think when it comes to challenging decisions, the courts is the right place for that to happen on balance.
Thank you, Minister. We're going to go to members now for questions, and can I ask Gemma to put her questions, please? Thank you.
Thank you, Chair, and I thank the Minister for coming. Again, I have to keep my camera off because our internet isn't great, so I know it's a wee bit rude, Minister, so please forgive me. But
it's fine.
I do appreciate you coming here today, and I'm actually glad that you did, because I'm absolutely not content with the inclusion of a police covenant in the consultation document. I don't understand the relevance or the need to have such a proposal in this document, because it's not part of policing oversight and accountability, which, as my understanding, was the subject of this consultation. And my other concern is why was it not included in the department's briefing paper for this session? You know, it lends itself to a perception that perhaps the department wanted to bury this issue and hope the members wouldn't notice it.
certainly wouldn't want to create the impression that we've in any way been trying to hide the issue. I think what we are looking to do is to see whether, given what has happened in the House of Commons in terms of creating a police covenant for members and former members of the police workforce across England and Wales, whether there is any appetite for similar approaches in Northern Ireland. So we are consulting on it, we haven't decided on it. I think that's the first thing to say. I think it would be odd, given that it is a live issue, if we were not to ask the public and indeed the committee and others for their views on it. And those who have strong views that it isn't the way we should deal with this, I think has an opportunity through the consultation to be able to do that. There are, of course, a number of initiatives already in place around PRRT and around the Northern Ireland Police Fund in terms of trying to support former officers and current officers. There's also the RUC George Cross Foundation, again, which is able to provide some support, and indeed staff associations being able to provide some support to their members. But I suppose the question is really one to say whether it is desirable to remove any disadvantage for members or former members of the police workforce arising from their membership or former membership, in the same way as, for example, the military covenant has been rolled out widely across the UK. So I think there is a benefit to asking the question in terms of allowing the public to give us an insight into their views when we go to consultation. But I wouldn't want anyone to think that from our perspective it is something that we, if you like, are specifically advocating for. The other thing just to be aware of, I suppose, Gemma, is this, that in terms of policing here, in terms of pay and benefits, there has been a broad acceptance of the parity principle, because it will be very difficult for us to attract officers from other jurisdictions, particularly within these islands, if police here are paid worse, or their terms and conditions are worse, or the support for them after they leave the service is worse than in other parts of these islands. So at least partly why we're putting this in for consultation is because of the parity principle and wanting to offer that consideration at this time as to whether or not we want to maintain that element of parity in terms of the rest of the UK, because that is something that is a changing landscape in terms of the national landscape. So I think that's the reason for it being in there. I don't think it's hidden. I mean, there's a fair bit of information on it in the consultation itself. But hopefully that has reassured you in terms of the reasons for us bringing it forward. And obviously it's not something that would have been in our radar at the start of the process, just given the fact that this has emerged as part of the policing bill in England and Wales.
Yeah, thank you. It doesn't reassure me. I still would be opposed to it being in the consultation document, to be honest. I understand the parity issue, but I don't understand how we could possibly justify including this proposal, given everything that's going on, especially with the likes of our health and social care workers and what they're going through at the moment, and the likes of the low-paid domiciliary care workers and other frontline workers. It does not sit comfortably with me, and I know myself and our party would not agree to the document going out to consultation with that included in it.
Well, as I said earlier, if I may, Chair, I mean, we're not seeking permission to consult. I have the power as a minister to consult on the paper. I'm seeking opinions in terms of the content of this. But I wouldn't overlook the fact that many people who have served in the police service have done so at considerable cost to themselves, in terms of having to move away from the community that they've lived in, having to be living remotely from family. They can often suffer significant disadvantage in terms of being able to find another job after they leave the police service. The costs that they incur, for example, as a result of security issues, can continue long after their service has ended. And I don't think it is unreasonable to consult on the issue of the covenant, because of course what it entails is simply ensuring no detriment, and no detriment doesn't actually advantage them over anyone else. It just ensures that they're no worse off than they would have been had they not been given service as a police officer. I don't see how that would in any way undermine support for health service workers are other low-paid workers. Indeed, if you look at some police staff workers and those who work in the police service more widely in staff grades, they also suffer detriment because of the work that they do, and they are not high-paid workers by any means. So I think it's just worth kind of considering that these are frontline workers given service in the community who may be disadvantaged as a result of that service. And all we're asking is whether or not we believe that there should be some proposal in place around a covenant to ensure that they aren't further disadvantaged when they leave the service.
No, I know that, and I'm not playing down the sacrifice that police officers make, but it just doesn't sit comfortably with me. And can I just ask you to clarify? So this is going out to consultation anyway, no matter what the committee says. Is that right?
Well, it will be going out to consultation. As I said, there's no statutory duty for committees to approve consultation documents or agree consultation documents. That responsibility falls to the Minister. But we're here today to listen to the concerns that you have, and then we will consider the document again before we decide to put it out next week. And so I'm listening very carefully to the concerns that you have. And again, if you want to speak to me or my officials in the interim, we're more than happy to listen to that in more detail. But yes, there is no requirement for the committee, if you like, to rubber stamp the consultation document. Now, that you may think that that's an advantage and that you don't need to take ownership of it when it goes out there, but you can also respond to it, of course, at an individual party level and say those bits that you agree and don't agree with. And I would encourage members of the committee to do so individually and collectively with their parties, because we need feedback from all key stakeholders, and I think our parties are key stakeholders in this process.
Yeah, no, I understand, and I might take you up on that offer and liaison with yourself and your officials in the interim. The other issue, and you have covered this, but can I just get you to run over it again about the absence of the powers to compel former police officers from the police ombudsman powers? Obviously, we believe that we would be looking for you to reconsider your decision not to address this issue. But can I just clarify what you said earlier? Sorry.
Well, the issue has been, if you like, that we haven't detected that there is significant consensus around compelling witnesses. So that is the first thing. There have been a range of views expressed, some of which I would have to say are fairly strongly held, would be, I think, the polite description around it. Part of the challenge is that if you are a serving police officer and you have to give evidence to the Ombudsman, you will have access to the contemporaneous notes that you took as an officer in that incident. You will have access to the resources that you're entitled to as a police officer in terms of representation and support. But crucially, you will have access to the events, a proper contemporaneous record of the events in question. If you're a retired officer, you don't automatically have that. And so I think if we were going to look at compulsion around those issues, then it would also raise questions as to whether or not people would have access to things like their contemporaneous historical notes, indeed whether those might even be available at this remove from some of the incidents. Most of the issues around compulsion for witnesses are very much focused on historic cases rather than on current cases, because the challenge tends to be more when someone has left the service than when they are currently serving, that it tends to become slightly more challenging for them in terms of making representations to the Ombudsman's office. We can't, there can be situations where an officer will not have had sight of the notes that they took in an incident, for 20 years and are then trying to rely on memory in terms of giving evidence. And of course, it's a basic rule of the justice system that you don't force somebody to say something that could incriminate themselves, and not least through lack of current recall.
Okay, thank you, and I'm sorry for making you go over that again, but
no,
thank you. That's my. Well, I would just hope that you would take my concerns on board on that of my party, and we might be in touch in the next week or so. Thank you.
Okay, no problem. Thank you.
Thank you, Gemma. And could I admitted to just a procedural issue that this session will be covered by Hansard. I should have said that at the beginning just for clarity, but also to say to members that Hansard have provided us that they'll provide a report of today's session, but it won't be in the usual timescale due to the pressures on so many other bill sessions across the Assembly. So just to have that noted by members. Can I go then to Sinead?
Thank you, Chair, and thank you, Minister and team, for being here today. And
At the outset, Minister, thank you for that clarification, because it was myself who asked the question about whether this was some type of statutory process that I had been unaware of or unfamiliar with. And what led me to ask that is in the letter to ourselves from the department, it does say that we're asked to approve the consultation. And I suppose in terms of the language of a committee, and that, you know, the request to approve something can have a different meaning, as opposed to a conversational piece, which you've described more wholly, and I commend you for that. To be fair, you know, it is an opportunity then to see that we have an opportunity to see what the department are thinking and their areas of priority, and indeed the pre-consultation period that has happened. So I do appreciate that, and it is maybe it was perhaps worth asking the question, because I think that was a bit misleading for me, and I don't know if others felt similar, but certainly for me it is good to hear that clarity. So just going back to then, what I won't be drawn, I suppose, to doing, however tempting, is to start to answer the consultation and the questions within it, and I can see why some people might be tempted to do that. So if I could just ask a few questions perhaps just about the process. So I've noticed that you did reference a pre-consultation engagement that has taken place. And am I correct in saying then, Minister, that that pre-consultation engagement, together with the Ombudsman's proposals, that you've taken a reading of what may or may not be contentious issues, and you've moved forward into this consultation with those issues you feel are not overly contentious? Or is this everything's in there and you're going to take a reading from the outcome of the consultation to determine what is and what isn't contentious and what can move on more quickly perhaps than other things?
Well, I mean, I think we said at the outset when we spoke to you back in February that our intention was, from the pre-consultation that we were doing with all of the bodies, there were some issues that I think it would be fair to say everyone was in pretty much unanimous agreement on. So I think it makes sense to go out with very specific proposals in those areas, and those would be more detailed. And you'll see that from the consultation itself. There were other areas where there was a degree of agreement that in principle things were right, but there were some questions remaining as to how those might be worked through in terms of delivery. Again, we were able to, I think, include that in the consultation in order to draw out some of those points. And then I suppose there's another category that we recognise were contentious, where there were directly oppositional views coming forward. And some of those we have included on the basis that we want to take wider views, because it's not that we've given up, if you like, on considering those issues simply because there's no consensus. But we are also conscious that in order for this to go ahead, there will need to be a degree of consensus achieved. So we are testing some of those issues which we feel have particular strongly held views. We're testing some of those in this. So there's actually precious little, and I mean, my colleagues can keep me right if I'm getting this wrong, but there's very little that we've said we're just not going to talk about it anymore. But there are one or two things that I think it's fairly clear from our discussions that just were not going to fly at this point in time, and we only have very limited resource, so we didn't want to focus our resource on things that weren't going to be able to be progressed, and that's the kind of way we've taken it forward. I was also keen, and I mean, I'm very aware that we've said it was going to be a short, sharp review. It has ended up being slightly more than that, in terms of it's been less short and less sharp than maybe we would have liked. Some of that's been just down to resourcing within the department, the challenges of being able to do the pre-consultation during COVID lockdown and so on. But I'm equally concerned that because it's taken longer, it doesn't end up snowballing to be something bigger than we had anticipated it was going to be. It's not about root and branch reform. It is about trying to resolve areas where there may be conflicts or frictions around the fringes of organisations, to try to provide clarity for the public, for those who use the system, and also for the organisations themselves. And so we're keen that, although it's taken a little bit longer than we would have liked, that it doesn't become a much bigger project than we had anticipated, because it is being done with relatively small amounts of resource attached to it.
Thank you. That is clearer then. And in terms of then that pre-consultation period and the stakeholders and the identifying of, you know, what is worthy of opening conversations, was there any political input to that? Did political parties have or leaders have a conversation? I did note a lot of the stakeholders being the obvious, Jenny, and the justice family, if you like. But in terms of trying to get an airing or a true sense of what is contentious, was there any political input on that?
There was. We met at the full session of the policing board, and representatives of all the executive parties were at that, and were able to give their views in the policing board, and as you would appreciate, did so fulsomely. And I can assure you, Dolores didn't let you down at all. She told us what she thought and was quite robust about it. So you were well covered and well represented at that meeting. Obviously, there will then also, I mean, as with any consultation, what I don't want to have is the pre-consultation dissociate the consultation, that it determines outcomes. So what we were trying to do was get a sense of where people were on some of the more difficult issues, and whether those were worth pursuing at this time or whether they would need to be worked through in slower time. And so it was really to try and shape that. I think we got pretty clear responses from the various organisations, and as I say, the political parties were included through the policing board. Conscious it doesn't cover every political party, but every political party will then have an opportunity to respond to the consultation itself, and it will be that will ultimately determine the outcome of the decision-making process, rather than the pre-consultation engagements that we've had.
Yeah, I appreciate that. And if I might, Chair, just two more quick points then. In terms of then you suggest that there may be, depending on the outcome of this, there may be some legislative change as a consequence of this. And I'm just wondering, because while some of it is quite focused, others are quite light touch questions in terms of what detail you would get back. So would it be anticipated that if an item was taken the route of going towards needing a legislative change, would there then be, this wouldn't be used as cover for a consultation has happened, that would perhaps invoke a more detailed consultation? And one more point, if I may, just after that question, is there any danger, Minister, in grabbing the quick wins here and leaving the difficulties on the table? And when things don't all progress together, some things never progress at all. I just wonder, sometimes getting momentum by pairing things, and has that been considered?
I think, and I understand where you're coming from on the second question, because I think political negotiation often takes that form where there are certain trade-offs and so on. I don't think that that's the way you could really do a review of an organisational structure for oversight of policing. I don't think that those trade-offs are things that we can engage in. It would be for the organisations themselves to think through what the benefits might be, as well as the disbenefits of the different offers that we put to them. In terms of consultation, you're right, some of the questions are more light touch than others. Some are more detailed because I think there's more developed policy in that area, or it's a more straightforward area of development. Some of them are slightly lighter touching, and what we're trying to do is in some of those maybe more contested areas to try and test out opinion and to try and draw out some more detail. Obviously, the detail of the consultation gives you some indication as to how developed policy would be in each of those areas. But if we were to bring forward legislation, we would do the normal legislative process. So there may have to be pre-policy development that would happen ahead of the legislation being drafted, which may itself require consultation. But at the very least, if we were bringing forward legislation, that would need to be consulted on. So I don't think there's any question that things will, if you like, from a very vague question end up in a bill without anybody having had an opportunity to have a further say as that's refined as we go. I mean, the department is very clear, and I'm very clear that what we need to do is have evidence-based policy making, not policy-based evidence making, and it's important that we go the right way round, that we do the research, that we do the consultation, and that we develop our policy based on the evidence that we have, not going ahead, even if we think we know where the evidence leads. I'm always very keen to test that, because sometimes The things that we presume are not always 100% accurate, even though they look very logical. So it's important that we test the evidence, and sometimes it means that things move slowly. Frustration of mine, frustration with the department, frustration I know for the committee, but it is important that we get these things right as opposed to just doing them right now. So we will certainly be consulting if there is legislation to be brought forward in the normal way, and we'll make sure that that's properly flagged.
Thank you, Minister. Thank you, Chair.
Yeah, and thank you, Sinead. And Minister, can I just maybe, and it's just for clarity, and apologies if this has been sent out to us, but currently there are two pieces of legislation which cover the operation of the police, which is the Police Act Northern Ireland 1998 and the Police Act Northern Ireland 2000. But can we get a delineation between what would require legislation and what would be policy, or what could be a change that could be brought about without legislation? Would that be helpful? Or apologies if it already is in the proposed consultation document, but just so we get clarity on that point, because I think there does seem to be a bit of confusion around what we can do legislatively and what we can do procedurally.
Sure. I mean, I think some of it is inferred in the consultation, but perhaps not as explicit, and that might be something we think about. We would certainly have that evidence, Chair, to be able to give you about things that may require legislation and things that would be able to be done administratively. We would have a fairly good idea of that at this point in time. But also it will depend on the results of the consultation, because how people want things taken forward in terms of their responses might also dictate whether it needs to be legislatively underpinned or whether people are content for an administrative solution to be sought. But we can certainly give an early indication to committee, if it's helpful, of the things that are likely to require legislation and those that don't. Though I think it's mainly in the consultation document.
The consultation sort of sets out when legislative changes required, so most of the legislative change would be for the appropriate recommendation. In actually the Stocktake, the one thing that requires legislation would be changing the requirement on the audit office, and if there was a view that the strategic oversight should be put in statutory footing, that would require legislation. Most of those are the main legislative changes.
Yeah, so we discovered that actually there wasn't a lot coming through in the Stocktake itself in terms of proposals for legislative change. As Lisa says, there is the proposal that the statutory requirement on the Controller Auditor General to do an annual inspection of efficiency and effectiveness, which is something that the Controller and Auditor General has actually recommended to us previously, and that would be changed to the 2000 Act. As Lisa says, if there was a desire to put the collaboration between statutory footing, that would require legislation, but it wouldn't be a change to anything that currently exists. The changes to the Ombudsman's powers would be changes to the 1998 Act. So I think there's very little that would actually touch on the content of the 2000 Act.
Well, just on that point about the Controller and Auditor General, was that not specifically in relation to the retrospective powers of the PSNI? Was that not a specific issue in relation to them? And I'm very loath to move into that territory, which is the responsibility of the Policing Board.
No, it was a requirement for the Controller and Auditor General to audit the board's performance plan and arrangements to secure continuous improvement. It was what was known as red flag. It was in England and Wales, so it was following that example.
Right. Okay. Thank you. That would be helpful if we could have something in terms of that separation. That might be useful for us in our consideration of. Can I go then to Rachel for some questions?
Thank you, Chair, and thank you, Minister, and thank you for attending this afternoon. And I'll say it again, earlier on, I have a smoke alarm that is beeping, so nothing to worry about. It's just very irritating, so hopefully it doesn't take over. A number of questions have already been asked there, but I want to just to clarify for my own information. The Policing Board membership and makeup, that is my understanding, that is dictated by the Police Act 2000 as amended in 2003 and then the 2018 Exercise of Functions Act. And that includes the membership of the board, including the political representatives. And you'll be aware from comments made earlier on that it is made up by political representatives of the executive parties. So I'm just wondering, has that come up? And who's decided that it's just the executive parties that are on the board?
Well, strictly speaking, it's not just the executive parties, it simply happens to be the executive parties on this particular occasion. It's by the hunt from the main parties is how it goes. So it's done by the hunt. So there was a time when there would have been members of the policing board who were not members of the executive, who would have been in opposition, and there have also been times when people were members of the executive and not members of the policing board. We have actually been in both situations as a party at times, as have some others. So it's not a direct read across to the executive. It just so happens on this occasion, Rachel, that it's a Venn diagram that is a circle on this occasion rather than two loops.
No, thank you. It's always just interested me just how that's happened, because there's been times within committee that, you know, I'm raising questions, and I appreciate that it might not be the committee's role, and you know, maybe it's stepping out of our bounds, but you know, we have no role in the policing board and no representation elsewhere. So certainly, I find that, and I appreciate why we're doing this Stocktake and why this is happening, and certainly clarity is key. In terms of the Ombudsman consultation more generally, and remember this coming up previously, is there any restrictions on who could be appointed as an Ombudsman? For instance, is there any conflict of interest considerations on who could take, you know, the position of the Ombudsman? Is that being looked at?
Yeah, there are no disqualifications, but there obviously, as with any post, if there are conflicts of interest that emerge over a particular candidate, those would then need to be resolved pre-appointment. There's no disqualifications as such to being able to do the role. But I think that's something, I'll check, maybe Maura, I think that's something that we are considering in terms of trying to strengthen that.
Well, the Ombudsman in her 5-year review report did include a recommendation that the legislation should be amended to provide for disqualifications from holding the position of police ombudsman persons who have been serving police officers. But in the consultation document, we've identified that as being part of the group of recommendations where we felt it was unlikely there would be a consensus reached that would enable such a change to be taken forward.
Okay, no, I think that's where I got it from, was the 5-year review. So that's not being consulted on through this in this process.
We've identified it, if you like, in the second part of things that we don't think there is consensus on, but obviously we're willing to hear views on all of those issues. So, I mean, if people have strong views, we're happy to hear those.
No, thank you. I just finally, this is I want to ask you about the Ombudsman report. Obviously, there's been much discussion about this over the last number of months, and indeed into last year, about the Black Lives Matter protests, and which I believe, you know, was very clear in its findings that the PSNI had not adequately considered the balance of human rights considerations, and the Ombudsman made a number of recommendations, and one in particular that the PSNI consider adopting a human rights-based approach to policing based on 4 principles, and it included evidencing identification of relevant rights, balancing competing rights, and it risks to include appropriate measures to address obligations and mitigate the identified risks. And so my question would be, just from your perspective, do you believe that the statutory duty of and the human rights reports conducted by the policing board are sufficient, or whether human rights considerations do need strengthened and embedded more in an explicit framework for oversight and accountability that governs the police?
Well, in terms of the oversight of human rights, as you know, the Policing Board has its own human rights advisor, but they can also take additional human rights advice if they wish to commission that. I mean, I can't comment on, and shouldn't comment or create narrative on whether or not the Ombudsman's report was accurate. The police have accepted the report and are working their way through those recommendations. I think what I can say in general terms is that I think human rights compliance is incredibly important. It was a priority in 1998 and it has been a priority since. And I think that we continue as a justice system to refine our understanding and responsiveness in terms of those human rights issues. I think that the current situation with respect to policing COVID restrictions has thrown up challenges for police forces right across. Not just these islands, but actually further afield in terms of the balance of individual rights over the collective responsibilities that are being placed on people to try and deal with a public health emergency, and that has been challenging. But from that challenge, I would hope that greater clarity would come in terms of how that balance can be achieved and how it can be achieved to the satisfaction both of the Ombudsman, the courts and the PSNI themselves, because I think it is important in terms of public confidence that those recommendations that the Ombudsman put forward are acted upon and are seen to be delivered.
Thank you, Minister. Finally, for me, and this is just on recommendation 11, and that's regarding the Police Ombudsman discretion to determine whether to begin, continue or discontinue an investigation into circumstances where the Police Ombudsman considered it in the public interest to do so. Is there any controls or criteria existing on that, and what would be the limits of that discretion, or is that something that we're consulting on to try and ascertain those?
Well, essentially, at the moment, and again, the sponsor team can keep me absolutely right here, but my understanding is that there is a kind of duty on the Ombudsman to consider every complaint that comes in front of them, and some of those complaints may be quite serious in nature, others might not be. Some might have a lot of substance and require significant attention, others may appear not to. And so I think really this is about the discretion to be able, if you like, to filter complaints, because I think it's worth bearing in mind that those who are complained about, once a complaint is launched, it can be an incredibly stressful position to be in. And if, for example, there are vexatious complainants who make repeat complaints about either individual officers or multiple officers and so on, I think that can be quite challenging. But Maura, I'm happy if you want to add anything to that, because I think, certainly having spoken to the Ombudsman, her concern was about focusing limited resources on those complaints which were substantive and had real basis to it. She also, and I think quite rightly, is keen to look at resolution beyond simply producing a report on a complaint. So the kind of early interventions that would allow people who maybe just want an apology to be able to find that resolution earlier, rather than have to go through a very formal process of complaint when perhaps people would simply accept an apology if an officer's been a little bit abrupt. An apology might be the answer, but sometimes that can be quite hard to get if there's a complaint system like the Ombudsman that sits outside and the police answer to every complaint is take it to the Ombudsman. Sometimes all it needs is kind of local resolution, and I think it's about that discretion. But Maura, I'm happy to.
Yeah, it's part of a series of recommendations that are included here, some of which have been made previously by other ombudsmen, that would allow for more proportionality in the investigation of complaints. And it's a recognition really of the fact that policing and confidence in policing has moved on significantly since 1998, when these powers were first created. So in the pre-consultation engagement, there seemed to be quite a strong measure of support actually for that more sort of streamlined, proportionate approach, whereas, as the Minister says, cases that don't require a full-blown investigation can be dealt with in other ways. And that links back to the point the Chair was making earlier about seeking to expedite the processing of investigations and the management of complaints. It could be very useful in that regard, and also allow for better use of the resources that are put into the Ombudsman's office, so that attention can be focused on the more serious and complex complaints that actually need that higher level of investigation.
I think it's also an issue, Rachel, that it can affect people's sense of satisfaction with the outcome. So, for example, if you have an interaction, for example, with a police officer, that police officer was rude or abrupt with you, and what you're seeking is an apology. If you end up in the Ombudsman's system and you then have to wait months and months and months for the Ombudsman to come back and say, well, you know, perhaps the officer may have, but there isn't any evidence on the body-worn camera, no offence has been committed, you know, that hasn't breached standards and all that kind of stuff, you can come away from that feeling, well, what was the point? Whereas, to be honest, if somebody had said to the officer, I think you should apologise, and that would sort it out, at the time, that person would feel that had the resolution they were seeking, rather than feel they've gone through a very laborious process to come out the other end empty-handed and frustrated. And I think it's that proportionality point, rather than trying, if you like, to sift out complicated complaints and not deal with them, or sift out things that they just don't want to be bothered with. I think it's about saying, if it's a simple complaint with a simple resolution, we shouldn't have to open a whole investigation file. We should just try to resolve it. And I think that that would be to the benefit both of the officer, who would probably, instead of being defensive about being investigated, would be able to say, well, okay, I can see why that might have been the case, and I'm happy to resolve it, and maybe see improved relationships between the public and the police. So hopefully it would be seen as a positive thing. But again, it's something we're happy to take feedback on from yourself and from others as part of the consultation.
Thank you. And I suppose if all parties are in agreement, is that more of a restorative process as well, open to the Ombudsman if applicable? But no, thank you. Chair, that's all my questions. Thank you, Minister.
Thank you. And just on that point, Rachel, in relation to the make-up of the policing board, as a former member of the board, it also, I think, and I'm right in saying this, that it depends on the results of the last Assembly election, and it's on that basis that the hunt is run. So the make-up of the board will change subject to the next election, whatever that may be, and some parties could end up with more members or less members, and that, I think, is still part of the framework of the legislation. So maybe hopefully that's useful. Minister, just to conclude with, in terms of those, and we mentioned the whole issue about challenges in terms of the Ombudsman's office, its functionality. And I was just looking at the last time that Sir Jenny did a report into the Ombudsman's office was in 2011, if I am correct. Now, my Google process could maybe be flawed, but if it was in 2011, and those recommendations were more to do with what they needed to do in relation to specific issues in regards to the police, and yet there was no recommendations that were in that report in regards to the function of the office. There was a section in that report about leadership, and it makes particular view or comment around the critical review panel of the Ombudsman's office, and it mentions a particular report that they had some difficulties. It was the investigation into the Lough Island incident, and it was published obviously in 2011. And it says this: these meetings were protracted, contributed to delaying the final report, and have further seriously divided the corporate and investigative functions of the Ombudsman's office. However, no recommendation, and yet I just wonder, would there not have been need for there to be an assessment of the effectiveness of the office before we start to look at how we actually would give more powers to the office? I think that's just the concern that I would have, and I'm not speaking now as chair of the committee, I'm speaking as a member and obviously on behalf of my own party. But clearly there is a gap between those two things, which raises serious questions about giving any more powers to an organisation that clearly has still questions to answer in relation to even its internal governance arrangements.
Well, I mean, a couple of things, Chair, just to answer your question. You're correct. So Jenny carried out an inspection into the independence of the Ombudsman's office in 2011, and it identified, as you say, significant concerns at that time around how sensitive, complex and high-profile historical cases were investigated and handled. There was a suspension of historical work at that time while the recommendations that Sir Jenny made were addressed. Oponi then were allowed to recommence their historical cases after Sir Jenny did a follow-up review in 2013, where they were satisfied that the issues that they had raised were being addressed adequately by the Ombudsman. There was also a Sir Jenny review into the methods the PSNI used around disclosure of information in respect of historic cases to the Ombudsman's office in 2020, and I think some of you may recall that was carried out at the request of the department in response to the Sean Graham case, when it emerged that some material hadn't been disclosed to the Ombudsman's office. The inspection recommendation in that case led to the publication of a revised MOU between Oponi and the PSNI to deal with it. In terms of Oponi's the kind of individual aspects of Oponi's work, but also the decision of Sir Jenny to undertake reviews, Sir Jenny basically have the right to undertake a review at any time in terms of a thematic inspection or an individual piece of work, or indeed a general inspection. and Sejini consult each year on their inspection plan. So if political parties, including your own, would be keen to see a more thematic review of the Ombudsman's office, you can, of course, at that point in time with Sejini launch their annual plan of work. You can fill into that that you think that it is past time that there was that wider inspection. As I say, from a departmental point of view, where we have requested one, it was because a specific problem arose at the interface between the Police Ombudsman's Office and the PSNI in terms of disclosure, and Sejini's recommendations then have been implemented to resolve that particular issue, and that was 2020, last year.
Okay. Doug?
Yeah, Minister, I mean, I'll be brief. The great thing about going last, everybody asks you questions and you've answered them really well, I have to say, and closed off most of them. Can I just ask your understanding, because what the Ombudsman is asking for is to include support staff and service providers within their remit. And where does that stop? For example, would that mean that an external service provider to the PSNI, such as training, could fall under the remit of the Ombudsman?
Isn't it? Yeah. I think it's to do with those who are exercising policing functions, Doug. I mean, rather than just anybody who's involved in terms of the policing family and support. So it would be about the exercise of their functions. But I mean, Lisa, do you maybe want to add anything on that?
Yeah, I think it's covering people exercising policing function in covering the contact with the public. It's not just any like a training provider. That it is people who are carrying out a policing function, whether that's police support staff or people who are engaged on a contractual basis through the chief constable. That's where it seems that it's probably not explained clearly enough in that report to make clear that's where it's applying to.
And I think the idea would be, for example, with the increasing amount of civilian staff that the police are using for matters that might have previously been dealt with by non-civilian staff. So, for example, at inquiry offices and so on. I think it's about trying to hold that to the same standard of service delivery and accountability as you would hold the police more generally to account. But I think it's more in that context of contact with the public than it would be just the kind of general third-party contractors and things like that.
And I guess that's the point that I'm coming from, Minister, and I get that kind of thing, but many of the service providers for the front-facing stuff the police do are external now. So, for example, if you're training police officers on domestic abuse, you might bring in Women's Aid, for example, as an external service provider to the PSNI, and the stuff that they pass on to the PSNI then becomes front-facing. Do you see where you could sort of blur the line slightly?
Well, the case there is that if you're training the PSNI, you're not doing it in direct contact with the public, and that's the key differential. It would be those who are carrying out those duties. So, for example, the Ombudsman may say, let's take a hypothetical example where there's a complaint around how a domestic abuse incident has been handled. The Ombudsman may find that the training needs to be improved, but they wouldn't be investigating Women's Aid and their training pack. They would be looking to the police to say, you need to put in place measures that would ensure that your officers are trained about X, Y, and Z in addition to what's currently done. So that isn't a change because they already do that in the Ombudsman's office in terms of recommendations for training going forward. So it wouldn't be for people who were back office staff. It would be for people who were either exercising policing duties. So things, I think it's like it's the kind of support officer roles that people would have now where they're exercising functions as a police officer and where they're in that kind of frontline role rather than people who would be providing training and support in back offices.
No, and fair one, that's pretty clear. And just a very brief one if I can, where it talks about making sanctions public from the police disciplinary panels, I take it that's literally just like a chart saying, this is a degree, there's no named officers or anything like that.
Well, this is one of the areas. This is one of the areas I think that was quite sensitive because obviously there is, for example, there's a proportionality test, there is a personal information test, there are issues around individuals being identified and so on. So I think that was one of the concerns that has been raised about the notion that things would be made public. It's about ensuring the balance between transparency in terms of what the Ombudsman does and what the office does and what the police do, but also it's about ensuring that people's personal information is treated with suitable respect, and particularly in a context where people may find themselves vulnerable because of their service in the PSNI. I think it's also fair to say that it depends to a large degree on the seniority of the individual, because there will be certain ranks of senior officer that will be well known publicly and be very public facing, and it may be different, and it may be a different scale of offence if they are being, for example, sanctioned, as opposed to a junior constable on the street.
No, that's fair enough, and you can see how that could fall into how a covenant could work to protect a police officer, but which I'm very supportive of, I have to say. But Minister, thank you.
Thank you.
Okay, thank you, members. If there's no other questions, Minister, can I thank you and your officials for the time that you've taken this afternoon to have this discussion around this matter. And if there's no other questions, then can I just bring this part of our proceedings to a conclusion? Thank you very much.
Thank you very much.
Much appreciated. Thank you.
Thank you. Okay, members, thank you for that. That means now that we can move on to item 6 of today's agenda, which is in relation to the Protection from Stalking Bill and the consideration of the draft report. And we will need your indulgence to work our way, I trust, methodically through this. So pages 46 to pages 155 of the table pack for the draft committee report on the Protection from Stalking Bill, which was also emailed to members yesterday, and also pages 156 to 188 for the draft executive summary section. The committee stage of this bill ends tomorrow. Members were therefore asked to submit any proposed amendments to the report by 10:30 a.m. this morning and enable these to be circulated in advance of today's meeting. There are no amendments that were received for circulation. Just to inform members that any typographical or formatting errors in the report will be amended at proofing stage before it's circulated to MLAs and published on the committee's webpage. And we will assume that there is no proposed amendments and will now move to seek the committee's formal agreement of the report unless there's any other indication, any other. Okay, then if we could move to the format of the formal agreement of the report, and we'll work our way systematically through this. This is the title page, the committee membership powers, table of contents, and list of abbreviations. You'll find our members content that is, I need to put this question, which are members content that the title page, committee membership, powers page, table of content page, the list of abbreviations stand part of the report. Okay.
Great.
I'll take your silence as content unless someone says no. And if it's, we'll work our way through that. The introduction section. The introduction section of the report is at paragraph 1 to 23. Are members content that the introduction section, paragraphs 1 to 23, stand part of the report? Consideration of the bill provision section, which is at paragraphs 24 to 293. Are members content that the consideration of the bill provision section of paragraphs 24 to 293 stand part of the report? Implementation of the legislation section at pages or paragraphs 294 to 343. Are members content that the implementation of the legislation section of paragraph 294 to 343 stand part of the report? Clause by clause consideration of the bill section, paragraphs 344 to 377. Are members content that the clause by clause consideration of the bill section, the paragraphs 344 to 377, stand part of the report? Other issues raised in the evidence received by the committee not currently covered in the bill section. paragraphs 378 to 385. Are members content that the other issues raised in the evidence received by the committee not currently covered in the bill section at paragraphs 378 to 385 stand part of the report? Appendices, are members content that the appendices stand part of the report? Executive summary, are members content that the executive summary stands part of the report? Seek the agreement of the members for the report to be published on the committee webpage and issued to all MLAs and to the Minister of Justice. Agreed. Seek the agreement of the members for the chairperson to clear the draft minutes of this meeting for inclusion in Appendix 2 to enable this report to be finalised. The draft minutes will be replaced by the final version of the minutes once agreed by the committee. Agreed? And seek agreement of the members to issue an electronic copy of the bill report to all the organisations and individuals who provided evidence to the committee on the bill. Thank you for your help in relation to that, and can I thank the committee team, the Hansard and the other Assembly staff and the departmental officials who assisted the committee during the scrutiny of the bill. And this concludes the committee stage of the Protection from Stalking Bill. And can I just say a word of appreciation and thanks to our own committee staff who are working under extremely difficult and challenging time frames in relation to all of these bills, and just say a word of appreciation to Christine and her staff, because a lot of work has gone in to getting this report to this stage so that we can meet the deadline for tomorrow. So on behalf of the committee, Christine, thank you to you and your staff for your work. Members, thank you for your help in relation to that. That brings us to agenda item 7, the Abortion Services Safe Access Zones Bill, and its information from the Department of Justice and the PSNI. You'll find that at pages 371 to page 456 of the meeting pack. The meeting on the 4th of November, the committee considered the correspondence from the Committee from Health, which sought this committee's views and comments on the Abortion Service Safe Access Zones Bill, and provided copies of correspondence sent directly to the PSNI and the Department of Justice. To inform its consideration, the committee requested a copy of any response submitted by the Department to the Committee for Health, and specifically any comments it had on whether the proposed new offences and penalties are in line with current sentencing policy. The committee also requested a copy of any response submitted by the PSNI, the Committee for Health, and specifically comments on the powers provided to the PSNI to enforce safe zone access zones and any potential resource financial implications. The Department has provided a copy of this response to the Health Committee, which outlines the Minister's support for the bill, and has confirmed that the maximum penalty of a level 4 fine is appropriate within the sentencing framework. PSNI has also provided a copy of its response to the Health Committee, which sets out what it considers to be a number of significant challenges around the interpretation and the enforcement of the legislation and potential resourcing implications. And it's just to ask members to note the responses unless there's any further clarification sought. Rachel?
Thank you, Chair. Chair, it's just maybe a point to raise. Point 4, the response from the PSNI stated that the overriding health considerations of the bill will inevitably draw it into legal challenge with the competing rights of the unborn child. I'm just wondering if we could maybe get some clarification from the PSNI about what they mean by that.
Okay. I'm just trying to bring this up at the minute, but I'm having difficulty with my tablet. Did that come from? Did it come from an ACC, or was it?
It was an ACC, Chair, and of course my pack is not loading.
No, mine is the same. It is frozen here. So, but no, we can.
White screen, total white screen, but it was an ACC, and I cannot remember. I might be getting it back. Nope.
Okay, thank you. Right, if we're agreed, we can.
It was Assistant Chief Constable Jones.
Yes. Okay. All right. Okay.
Thank you. Okay. Thank you, Chair.
Thank you. Okay. And then the other one is whether, just to seek the views of members on whether any views or comments should be submitted to the committee for the Committee of Health in relation to this bill. But I think we have gathered the information that we need, and this is obviously an issue for that committee now to take forward. Okay, thank you. And I think we should send a note to the Health Committee just to say that we have noted the responses from the Department of the PSNI in relation to the bill. That brings us to item 8 and SL1, the County Court's Financial Limits Order, Northern Ireland 2022. You'll find that at pages 458 to 469. The Department intends to make a statutory rule to increase the small claims jurisdiction of the County Court in Northern Ireland from the current level of £3,000 to £5,000. The Financial Limits Order will be subject to the negative resolution procedure, and the Department is making this order powers conferred to it under Article 22 of the County Court's Order, and this power is exercisable after the consultation with the Lady Chief Justice. The Department completed a public consultation in February 2021 on increasing the general civil jurisdiction and county courts in Northern Ireland. Following this consultation, the Minister was minded, subject to business case approval and statutory consultation with the Lady Chief Justice, to increase the jurisdiction of the county court limit from £3,000 to £5,000. Committee noted the outcome of the consultation and proposed the way forward at a meeting on the 18th of November. And it's just to seek the agreement of the members to ask the Department to provide further information on the time frame for consultation with the Lady Chief Justice, and also whether, if there is any other comments, clarification required in regards to the statute. Thank you. SL1, the County Courts Amendment Rules Northern Ireland 2022, small claims. You'll find the information at pages 471 to 476. The County Courts Rules prescribe practice and procedure in proceedings in the County Court, including the forms to be used in connection with applications under the County Courts Northern Ireland Order 1980. The rules are made by the County Court Rules Committee, subject to being allowed by the Department. Consequential to the Minister's intention, subject to the business case approval and statutory consultation with the Lady Chief Justice to increase the limit for small claims jurisdiction to £5, the County Court Rules, sorry, that should be £5,000. The County Court Rules Committee will be required to amend references in the County Court Rules Northern Ireland 1980, which refer to the financial limit. Presently, they reflect the current 3,000, and amended references will reflect the new limit of 5,000. There is no general or statutory requirement to consult on the County Court Rules, as the amendments are consequential on the implementation of a proposal consulted upon in February 2021, as detailed in the previous item that we have already considered. And it's to seek the agreement of the members to wait for the response in respect of the consultation with the Lady Chief Justice on the previous statutory rule before making a decision on this proposal, given the connection of the two. That brings us to item 10, the modern slavery, human trafficking, transparency in supply chains, outcome of the consultation and next steps. Pages 478 to 566 of today's meeting pack, following off the meeting of the 28th of January, the committee noted the Department's plan for engagement with public and private sector bodies about the changes to the transparency in supply chains arrangements. This followed the UK Government's consultation on the proposed amendments to Section 54 of the Modern Slavery Act 2015 and the next steps to strengthen transparency in supply chain arrangements for commercial businesses, and for the first time to extend them to apply to the public sector. As the proposed changes relate to a mixture of reserved and devolved matters, legislative consent is required to extend the UK Government changes to Northern Ireland, and there will be a limited scope to deviate from the Home Office approach. Therefore, although modern slavery policy is devolved, any amendments to Section 54 will apply to businesses that are in scope of the legislation within the devolved administrations. The Government's consultation did not extend to Northern Ireland, so the Department advised of its intention to seek views on a range of proposals, and having sought and received clarification on the process of consultation being undertaken by the Department, the Committee agreed to receive an update on the outcome of this exercise and proposed next steps in due course. A total of 12 responses were received, and the Department has outlined the responses reflect widespread support for the strengthening of the transparency in supply chains arrangements. Key issues have, however, been raised around the need for guidance, support, training, a better understanding of the need for the transparency beyond Tier 1 supply chains. The Department has also highlighted that some of the issues raised in response to this consultation will be considered in the longer-term approach to the Northern Ireland modern slavery and human trafficking strategy. So, should the Home Office determine a date to legislate for the additional measures, any changes would be subject to the support of a legislative consent motion within the Assembly. No further detail has been provided by the Home Office on when it plans to legislate, but officials have committed to keep the committee updated. And it's to ask members to note the summary of the responses to the public consultation with commercial sector businesses and the public sector on the transparency in supply chains, unless there's any further information or clarification that's required. Item 11, Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021, implementation of Section 28, the Domestic Abuse Waiver for Legal Aid, and this is an update. Can I just check, Sinead, is this on this issue or the previous one?
This issue, please, Chair.
That's okay. Okay. You find this?
Chair.
Yeah, go ahead.
Sorry, I just appreciate the update on this, and I just want to take from it. I note some of the options papers that were put together in the outline business case, and I note particularly on page 584. They talk about revised rules for contributions, and on 585 that the implementation preferred option was to commence in November 21. And I would just like something back from the Department on those two issues. Has it commenced, and what can we have the detail of what the revised rules are?
Okay, because we had requested further information on the timescale for the completion of the outline business case and a copy of the OBC, including the options considered. The committee also sought confirmation that the Department has fully explored and concluded that there is no repercussive effect, and requested a copy of the paper trail to establish this. So we had considered the response from the Department at our meeting on the 21st of October and agreed to seek confirmation that a copy of the outline business case, which will consider the options for the evidential test to be applied by the Legal Services Agency, will be provided to the committee when finalised, and again request a copy of the paper trail for the Department's exploration and conclusion regarding the potential repercussive risk. So the Department has responded advising that the outline business case, considering the options for the evidential test to be applied by the Legal Service Agency, is currently being prepared for submission for approval, and it would not be appropriate to share the document at this stage. The Department has provided letters summarising the legal advice obtained regarding the potential repercussive risk and a copy of the strategic outline case, which the documents and the explanation of the repercussive effect. So the Department will provide a further update in January, which will include the information on the communication strategy and the raise awareness of the waiver. But we will correspond with the Department on the back of Sinead's query. Rachel?
Thank you, Chair, and thank you for that very comprehensive update in terms of what we have in front of us. There's obviously a lot here. I suppose it's very helpful to see clearly in the strategic outline case that the repercussive risk has been deemed as very low, and it's also good that the necessary engagement with the stakeholders have been sketched out and planned in this document, so that's certainly welcome. But in terms of the further update on this in January, as part of that, I'm wondering if we can get a confirmation from the Department of the list of stakeholders that they've engaged with in developing the evidential test, and they also said in their letter from the 12th of October that the OBC would be submitted to the Department of Finance by the end of November at the latest. So I suppose an update in January on whether or not that has been completed and what the next steps are would be very helpful.
Okay, thank you. Okay, members, that brings us to item agenda 12, correspondence. There are 4 items of correspondence at pages 633 to 661. I can draw your attention to one of the items in the meeting pack, and then if members have any other comments in relation to the correspondence. It's item 12.2 at page 635 to 638. It's correspondence from the Minister of Justice outlining the discussions and engagement that has taken place regarding the scheduling of justice bills to ensure all necessary legislative stages can be completed before the end of the mandate. The Minister has outlined the pre-planning and the engagement that her officials have undertaken, and she's confident that all bills can complete their Assembly passage in time. And it's just to ask members to note the position and advise them that the focus of the committee will now be to complete the committee stage of the Justice, Sexual Offences and Trafficking Bill. And if you're content, unless there's any other questions in relation to correspondence. Rachel? No? Okay. Then say, are members content to action the rest of the items of the correspondence as set out in the cover sheet? Content? Thank you. Just one item of Chair's business, you'll be glad to know, and that is correspondence from the PSNI regarding the planned violence and intimidation against women and girls stakeholder event. In light of the recent developments with regard to COVID-19, the PSNI have decided to move its planned stakeholder event for the 12th of January 2022 in the Long Gallery, which the committee had agreed to sponsor, and they're now moving that to an online event. And you'll find the relevant correspondence at page 180 of the table pack. So it's just to inform members that that will now be an online event. And when we have any further information in relation to that, we'll forward that to members. Item 13, any other business? If there's no other business, then can I advise that the next meeting of the Justice Committee will take place on Thursday, the 16th of December 2021 at 2 p.m, and it'll be in the Senate chamber, and there will be a meeting of the committee on that occasion, and I hope that that will hopefully bring us closer to having a few days when we will get a bit of a break from legislation, but clearly we've had a busy number of weeks and months, but can I thank you members for your help in getting through again today's business. Thank you very much. Thank you.
Thank you, Chair.
Thank you.
Bye-bye.